without issuing any show cause notice. Yesterday I received it. You will have to kindly grant me leave so that I can move it on Tuesday.
Lordship, one more thing. It is already mentioned, matter has come from the SA department, but not yet listed. That's why I am
Not yet listed.
listed.
When you mention it,
It is the matter was came here on 7th February, but till date we have searched it, but the department is taking that we have given it from registered department. That is also informed. I have gone there to
So where
find
is
the file. No, I don't know why the file. And Mr. Registrar told me that to mention before you. And copy of the register.
mention করেছে বলছে no, whether this mentioning was allowed?
Yes, allowed. And so requisition was going there, and they have sent the file here.
It's a hearing of 2016.
Yes.
Recently, I am taking the hearing matters till 2010 only, not 16. However, whether it was mentioned
At least
was
file.
allowed.
Yes, mention was allowed, and requisition was going on there.
Yes.
May I have your lordship's leave, my lord, to mention item numbers 11 and 12 of your lordship's list?
Today's
My lord,
list.
Today's list. My lord, these are, my lord, criminal revisional applications, which your lordship was, my lord, kind enough to take up on 6th of March with a direction that the matters will appear. These matters were taken up because my lord Justice Ajoy Mukherjee, who is holding the regular bench, was in circuit, and his determination was with your lordships. And your lordship has passed an order on 6th of March, my lord, staying the warrant of arrest till today, and directing the matter to be, my lord, listed today, that is 28th of March,
Today before the court.
before the appropriate bench. Now, my lord,
Why it is appearing in
my
this
lord,
matter?
perhaps inadvertently it has appeared before your lordship. My lord, I have two difficulties, my lord. One is, my lord, that, my lord, my warrant of arrest, the interim order that your lordship had granted on 6th of March, my lord, is ending today. And secondly, my lord, the other difficulty is, my lord, that my lord, there is an extended weekend perhaps, my lord. So in case, my lord, the warrant, the interim order is not extended today, and the warrant is not, my lord, stayed, or the interim order is not extended, my lord, then, my lord, I'll be in deep predicament, because if, my lord, the warrants are executed, my lord, we'll be in jail serving out the sentence.
I am appealing.
Learned friend appears for the complainant.
এইগুলো কেন অর্ডার হয়ে যাওয়ার পর রেখে দিচ্ছেন কেন? এগুলো আমার ডিটারমিনেশন নেই, এটি রেখে দিচ্ছেন কেন? তো ভূত পার্টি অবস্থা শুরু করছে। Without jurisdiction.
My lord, the difficulty is, my lord, on last
Technically not, my lord, technically not to some extent, my lord, because since the matter is before your lordship and your lordship is releasing it, my lord, perhaps your lordship will be minded to release it, my lord, and
Yes,
direct it to be placed before the regular bench. But
50 days.
because of the peculiarity of the circumstances, my lord, I do not know, my lord, whether my learned friend will oppose this or not. But if your lordship
My lord, I
extends
will
my
oppose
interim order,
only- I will
extends
oppose-
my interim order till, my lord, Tuesday or Wednesday, and, my lord, directs it to be placed before the appropriate bench, subject to the decision of the, my lord, jurisdictional bench, my lord.
My lord,
If
I
my
will
learned
oppose
friend
only
opposes, I have
only
nothing to
because of
say.
two things, my lord. Because only, my lord, they have already filed an application for extension. So that is pending. So there is no issue regarding the extension. Secondly, my lord, on the last occasion before the landed trial court, they did not even inform or intimate the order passed by your lordship, my lord. This is, we have informed, and in fact, there is a non-execution return, and we did not take any steps pursuant to the order
lord,
passed by your
Well,
lordship.
that is
So
why,
that
my
the
lord, I
dying-
always say Mr. Lahiri is always very fair to his opponent. my lord. He's very
lord,
fair, always,
my
my
lord,
lord.
my lord,
No, no,
my lord,
but
Mr.
I
Lahiri
must-
is not
I-
talking about you, talking about your client.
Yes,
my lord,
that is true.
so there is no dying urgency, my lord, for passing and extending the interim order today itself. If your lordship kindly direct this matter to be placed before the appropriate bench on Monday itself, my lord.
Monday is a holiday. I was only requesting your
Tuesday.
lordship to this matter to be placed on Tuesday. Until Tuesday, kindly extend my interim order. Or till Wednesday.
Justice Mukherjee has the determination.
Yes, now
yes,
Justice Dr. Ajay Kumar Mukherjee has the determination.
Determination.
Lordships.
Today you have seen the list.
Yes,
Today,
yes,
yes,
today,
it is
today,
there.
yes, today.
Because my lord had taken up the matter because Justice Mukherjee was in circuit. And your lordship had the urgent
I am
determination.
not talking about that.
Lordships.
Today some determination has been changed.
Change. No, but today it is there. Na?
It is
Justice Mukherjee
Justice
determination.
Mukherjee.
Justice Mukherjee has given perhaps the bail bench.
From Monday, I guess. From Tuesday, my lord, I guess.
Yes, that's why. From Tuesday it would be.
Then your lordship says appropriate bench. my lord.
Yes.
Appropriate bench.
Very.
Well, as of today, there is determination.
Kindly protect
Today
me.
is
Today there is.
Today it is there.
since first it would be otherwise.
Yes. And will kindly protect me till Wednesday, my lord. Till Wednesday.
Well, in
Very
that case, kindly dispose of the plan. Will it?
No, very well. I'll
That
no,
I leave it
don't
to
have
you,
the
lordship.
determination now. If I pass any order, it would be otherwise.
And the extension of interim order will it pending of a
No, since it has
application
been
will it-
listed, my lord, this inadvertence, my lord, will otherwise throw my client in jail, my lord. That is why, I have made this, my lord, very respectful request to your lordship, my lord. My learned friend will also understand my predicament.
Very
Then-
well. I'll pass the order.
Lordships.
I'll pass the order. Let me call the matters. Other matters.
Lordships. I'm deeply.
Regarding item number 90 and 91 of today's list, I am praying for updatation, Lordship. The private respondents are selling the plots of land, though there is a status quo order, Lordship. Item number 90 and 91 of today's list.
90 and 91.
91. Yes, Lordship, I am praying for upgradation. The private respondents are selling the plots of land, there, though there is a status quo order. Lordship, kindly take this matter on next Friday, Lordship.
Have you
Kind-
filed any application for injunction or like that? Who are you? You are for
I
the
am for the
appellant.
appellant, Lordship.
Who is for the respondent?
Respondent, service service has been affected, Lordship.
No, before mentioning you have to serve. Before mentioning you have to serve. Whether you have served. No, before mentioning you have to serve.
Lordship,
You
the-
mention it
I
on the
will-
next Friday.
no, Lordship, I will serve them notice today only. Lordship, kindly take this matter on next Friday, Lordship.
Next Friday I cannot take up this matter. I have some other matters next Friday. I have fixed several matters. There are old pending appeals.
Lordship, kindly take this matter. Lordship, kindly hear out this matter. They are selling the plots of lands, Lordship.
You know, both the parties are required to
Yes,
be
yes, I
heard.
shall serve.
Otherwise, I cannot hear
Previously,
you
previously
alone.
service has been affected, Lordship. Today I shall serve notice again.
Today,
I have
what
served-
is the purpose for service? You have to mention after service.
Lordship, kindly.
If both parties are there, I can fix a date. You can understand the issue. Otherwise, I can fix a date. He will say, no, I am not ready. In the second appeal, that cannot be done. Both parties should be ready. You serve it and mention it on Monday.
Monday.
Tuesday,
Yes.
my lord.
Monday.
Oh,
Tuesday.
Tuesday,
Tuesday.
Tuesday. Yes,
My lord, I
Lordship.
also had a similar
Okay.
prayer, my lord. I will also come back on Tuesday.
On
my lord.
Tuesday, you
Yes, yes.
serve it
I-
and
I understand.
mention it that this matter would be mentioned on that day.
Yes,
Tuesday
yes.
is the day. Okay.
Great, Lordship.
Substitution application, my lord.
Today is not day of mentioning. Okay, you know the matter. Monday and Wednesday.
But with regard to item number 37, I've taken consent, my lord. I am only praying for not today, my lord. 37.
Item number 37.
37.
You are for the
Private defendant respondents. And I've already,
who
with
is for the appellant?
appealant, my lord, to please Samuel. Now, brief has been no objection and did not given. Now, my lord, Suranjan Mondal is not the advocate on record. However, I am the dependent respondent.
37 pending for applications.
Application. There are 3-4 applications. Probably one copy application not served. However, my lord, only not today, my lord.
Okay, I'll call the matter.
Yes,
Not today.
not today. Only.
Right. Call the matter.
My before calling my lord, item number 17. My lord, at my instance, the matter has been listed. But today, my lord, the affidavit of service has not been brought. My lord, if you also signing again, not today.
What do you want?
And only not today, my lord. Next I shall.
You are for the?
I am for the appeal.
Okay.
I'm good. 17.
Call the list.
Lawsuit. Item number 2, I am appealing on behalf of the appellant
And 3, I am appearing on behalf of the respondent.
Take the mic, please. I cannot hear you.
I am the appellant in one appeal and the defendant in another appeal,
Respondent and another appeal.
respondent in another. appeal.
Yes. Why it is appear today under the heading of two mention?
Lordship, everything is
Actually,
completed.
what I am submitting, today it has come up for hearing. What I am handicapped today because I have not received the evidences of the witnesses of the trial court. That is also not on record. I request my learned friend to give me copies of the evidence.
Whether evidence is required in the second
Not
appeal.
record. Otherwise,
Paper books are ready.
paper books are ready. Here,
And as
here
already served.
the appellate order of the first court has been challenged by both the parties.
Is there any cross appeal?
No, no.
Two appeals are there.
Two appeals.
Two appeals
Lordship,
by
I
a
was
same order.
Challenging the same order.
Same order.
Same order. Lordship, fact is that suit for eviction. I am the plaintiff. Filed by my client. Suit decree in part. Holding that the notice under section 106 is illegal, but directed the defendant tenant to pay the rent under section 114 of the TPI. I prefer an appeal. Appeal court allowed the appeal in the body of the appeal to dispute regarding 2 rooms. One sub room. My case is that I inducted the defendant as a tenant in the said sub room. Subsequently, one go down. That was not the within the tenancy. That was the dispute. In the appeal court, appeal was allowed, holding that no, there is the only one sub room. Notice was served to that extent, and plain case was to that extent. So appeal was allowed. Only ordering portion, wrongly it was written, go down. But all the body of the judgment, it was written is a sub room.
So why you not prayed for modification?
Yes, I prayed for modification. In the court below, passed an order holding that already appeal was filed, so I cannot correct this. Already
This is your appeal.
My appeal
For only for the modification was not considered.
not considered.
And
Only
your appeal,
I filed the appeal.
you are
before
the tenant.
I am the tenant.
You filed the appeal on the merit.
On merit.
On merit.
Because I have been directed to vacate the go down, which is a part of the tenancy. That is my case. Kindly give me some
Let's
time.
start the argument today.
No,
I am ready.
I have not read the evidence of the witnesses of the trial.
Court appeals of 93.
Yes, that I have seen.
Should must have much prior to that.
suit lordship, title suit lordship.
Due to death of the lawyer of the lower court as well as his clerk, the file could not
Take the
be.
certified copy. This is the- there in the LCR.
1989.
89 is the
Lost.
suit. Now we have lost 30 years.
Yes,
More than 30 years we have lost. 35 years lost.
that is why all are dead, so old.
Now you take certified copy from
Yes.
the LCR, that will be sufficient.
LCR is not here also.
LCR is not here, what means?
No, LCR is there.
LCR আছে না?
Yes, yes.
কোথায় পাঠিয়েছি আমরা? না, LCR ওখানে আছে তো? ঘর সব এসে গেছে LCR। বাকি LCR টা কোথায়? Must have it is in the department. Why part LCR?
Only
কে বলেন রেকর্ড গুলো রেখে দিয়ে কি সমস্ত ঝামেলা করছেন, একটু মাথা খারাপ এইসব ফালতু জিনিস রেখে দিয়েছেন। কেন রেখে দিয়েছেন আমার কাছে? আমার ডিটারমিনেশন আছে, আমি অর্ডার পাস করবো। এইটুকু এলসিআর কে পাঠাতে হবে?
Give me liberty to apply for the certified copy of the order. If the lower court
Part
record,
LCR has reached.
that is the problem.
So you take instruction.
Instruction,
Appeal cannot be live. like that.
That is right. But the lower court learned advocate died long before and his clerk. All documents are
The
with.
second appeal, what is the necessary for the evidence?
Evidence is required in the present case. Otherwise,
What is the substantial question of law in these appeals?
No question at the time of admission, no substantial question was framed.
Then why you?
My appeal loss is only one question.
Whatever may be the question was
That was
framed
not-
or not?
That was not framed.
Then
To appeal, that was
why
not.
why it is ready?
My appeal was admitted on 18th January 1993.
Our paper কোথায়?
And second appeal was admitted, second item appeal was admitted
Admission order to paper. Second appeal, 310 of 94.
that was my landed friend appeal. My appeal is 478.
my appeal was admitted by the division bench presided over by Lord Mr. Mukul Prakash Mukherjee, but no issue was framed at that time. The appeal will be heard.
At the admission, only appeal will be heard.
আমাকে দিন আমি বের করে দিচ্ছি আমাকে দিন
It was 310 admitted on 11/11/1992.
What are the substantial question of law involved in the appeal?
In my appeal, Lordship,
No,
I-
310.
310.
Yes.
Miller,
What are the merit?
the merit of the case is that tenancy includes the go down. That is my case. It is not a separate room. One room was given for tenancy that includes the go down also, along with the shop.
Just wait. Where is the memo? 310.
see, in the paper book, it was annexed.
করেন না ফালতু ফালতু জিনিসগুলো আমার মাথায় জড়িয়ে যাচ্ছে এর জন্য একটু লিখে করে এই করে যা হবে না কোনো আইডিয়া নেই 310 give me the paper book.
Yes, paper book also filed, Lordship. In the paper book, it was annexed, page number 24.
My case is
So
that
in the first appellate court observation is that you are tenant only in respect of room number 3,
only
that
one
is the
room,
sub-
only one room.
only one room.
My case is that the go down
But the ordering portion is otherwise.
otherwise.
So what you want now?
The tenancy includes the go down.
Tenancy includes the go down, that is the other way, but the ordering portion of the learned first appellate court and the observation in the body of the order of the appeal is otherwise.
But your lordship kindly
Both are
see the order.
self-contradictory. What you challenge? The final order or the body?
Final order.
Final order in favor of you.
No. Final order is for vacating the go down. But my case is that tenancy includes the go down also. That is attached with the shop room. The go down is not a room. The go down is not a room. The learned the assistant the district judge are in law by holding that the go down is a room. Go down is not a room. It is attached with the room which has been given rent to me.
So room number 3 is not the go down.
No, room number 3 is.
Room number 3 is the sub room.
Is the sub room, and the godown is attached with it. Tenancy includes the godown also. It is not a separate room because it has no door or window except the door inside my sub room. If it is a room, it has separate entrance, or there must be windows, but no window, no door except the door from which I enter through the sub room. But it is admitted position that I am in possession of the sub room and the godown. If the godown is not a part of the sub room, then how can he got possession of the godown?
Get ready within 2 weeks. Both the appeal would be heard.
Yes.
Please take down. Within 2 weeks.
Liberty may be given to apply for certified copies, which are before your lordship.
You take the responsibility to get the
But
certificate.
lot of record is not traceable, that is the problem.
Now at the time of hearing, you are just taking the notes off.
No,
Now, by that way, I cannot allow the tenant to be there.
no.
No, they already 30 years, 35 years has elapsed. You are enjoying
No.
the.
And
Yeah,
nothing was paid.
tenancy in respect of the eviction or go down. My sub room is there.
No,
I know
So-
they now. I know you have a merit in the case. But why you are not ready?
No, ready
This
because
is not my headache. You have to
no,
get
no,
ready.
that I know. No, it
Then
is my responsibility. But
Long appeals
due
are
to
pending in the
death of the
list.
learned lawyer of the lower court, I am
You
helping.
take instruction what you want.
No, I request my
I am
learned
fixing
friend
the matter.
to give me supply of the evidence. I
So
will
what
pay the
time
cost
you
of the
want?
jury.
I am fixing the matter on the 2nd week of April.
Second week of
April.
Make it third week, second week I am. After 15th. After 15th April.
The third week is all holidays.
No. That first Boishak is the holiday. Thereafter, court reopened. Oral evidence is required because that has been discussed.
So you have to collect it earlier.
I requested my learned friend to
I am not
supply
bound to
Information you have to
supply
collect
this
it,
copy
otherwise
also.
the matter cannot be proceeded like that.
like that. That I know.
Then
I'll pay the cost
you
of
filing
Xerox.
appeals, you must get ready. You are one of the appellant of this matter. Please take down. An accommodation is sought for on behalf of the appellant, being SA number 301 of 1994.
310 lawsuit.
310, 1994. Concerning the submission, the matter be adjourned for the last chance. List the matter on 24th of April
24th of April.
at 12:30.
24th
24th of April, 12:30. For hearing of both the appeals.
lawsuit.
Full stop. Next, it appears that no substantial question of law has been framed in those appeals. Full stop. The substantial question of law would be framed at the time of hearing of the appeal on the adjourned date.
Lawsuit.
Next,
Off record, may I request my learned friend to supply me copies? I will pay the cost of photocopies. No.
No lawsuit. If I am relying this evidence, then I supply at the point of.
very.
No, I can rely
You
on
take instruction, otherwise this matter cannot be go like that.
that I know. But
Then-
difficulty is that unless the lower court records are traceable, that is the
The
problem.
appeal is pending since 94. Now you are saying the lower court record is not there. What is this?
Learned advocate is dead, the lower court. That
Then you have to take steps before mentioning. Yes, next.
My lord, second appeal, my lord, extension of interim order.
We have not been served with any notice of, they have mentioned the matter. Lordship may fix up any day for hearing the matter,
Yes,
the
my lord.
whole
Any day
matter,
convenient to my lord.
any day convenient to your Lordship.
Last order, my lord, was pleased to extend the 24th December 2024.
Who are you? You are the appellant.
Yes, my lord.
Where is the interim order?
My lord, last order, 24th December 2024, lordship was pleased to extend the interim order to the
Yes,
31st
sir.
of March 2025, my lord. Matter was kept for hearing.
When
on-
the interim order was passed, first order.
My lord. 22nd August, no, no, last order.
Appeal of 97. And you are extending the interim order.
My lord, any date convenient
Time
your
to
lordship
time.
will-
What is CAN 4?
Lordship, CAN 4 was the restoration application, which is not yet taken up for hearing.
Restoration application.
They have filed an application for restoration.
Restoration of what?
Lordship,
Restoration of appeal.
Lordship, the SA 286 of 1997 was by order dated 8th August 2024. There was a order for dismissal. After
for
that, the
dismissal?
CAN 4 was preferred.
SA 286.
SA 286 of 1997. Lordship, order dated 8th August 2024.
286.
My lord, I have a leader in this matter. May I come back, my lord?
Now what is 287?
Lordship, connected applications,
No. Appeals.
connected appeals.
Connected appeals.
Yes,
Only
Your Lordship.
single appeal was disposed of. Two 286 of 1997 was dismissed for default. So how can I extend the interim order in a dismissed appeal? Huh?
Your Lordship, Your Lordship, if I may have Your Lordship's leave to appear virtually in this matter because I am suffering from fever. I appear for the appellants along with Mr. Shah. Your Lordship, the second appeals were dismissed for default. We had immediately within time preferred restoration applications. When the restoration applications were taken up by a coordinate bench of this Honorable Court, we also pressed for hearing of the appeals. So the coordinate bench passed an interim order stating that I will hear not only the restoration is a matter of course, but I will hear out the appeal, so come back. Mr. Jishnu Shah is leading us in the matter. Mr. Jishnu Shah started making submissions on the appeal, and that is recorded also. Then an interim order was passed with the understanding of both the sides that the appeal will be heard. Then, Your Lordship, the paper books were not ready, and the paper books were not before this Honorable Court.
So
And then the
how can I
exercise.
extend an interim order in a dismissed appeal?
My lord will kindly have
Your
the order of
Lordship will
22nd August.
Yes. And Your
Kindly have the
Lordship
order
will.
of 22nd August, my lord. It's
Order
22nd August 2024, my lord.
22nd August.
Yes, my lord. Kindly see, my lord. Last paragraph, it has 22nd August copy. Says, my lord, IA CAN 24 is an application for restoration. Same is pending for disposal in the interregnum, my lord. Status quo was directed. So that is being extended. My lord, second August. My lord, may I hand up?
8th August 2024 is the order.
My lord, 22nd August was.
I have seen the order. Not necessary.
My lord,
28th August 2024, interim order, if any, stand vacated. All interim orders vacated. When the matter was disposed of, dismissed for default.
August. My lord, 22nd August, Lordship has been pleased to extend, my lord, the status quo order. My lord, because the appeal was being heard along with the restoration application. My lord, the Honorable Judge was of the opinion that simplicity restoration should
Where is
not-
the order that the appeal would be heard along with the restoration application?
My lord, kindly see 22nd August, last paragraph.
Yes, can 5 of 2024 is an application for restoration and the same is pending for disposal. Let there be an order of status quo till 30th September 2024.
Yes, my lord, because
Where is the observation that the appeal would be heard along with the restoration application?
no, that is what was in fact being done, my lord. That is why, my lord, even pending the restoration being allowed, my lord, the interim order was being continued. Because, my lord, the
How
order-
can the interim order be continued in a disposal dismissed appeal? When appeal is dismissed, there is no such. Even in the order of dismissal, all interim order was
kindly allow us to come,
vacated.
my lord, then kindly allow us to come back. We will move the restoration application before your lordships. If your lordship is minded to hear the restoration application
Not
separately.
of minding anything. What you are proceeding, that is the question. How you are proceeding maintaining the interim orders. In appeal, which is no more now. And you are enjoying the interim order. This is the situation here.
I have a leader in this matter. Let us come back to your lordship, my lord, with the restoration application, to move the restoration application in that case, my lord. Lordship will see last on 24th December also interim order was extended till the 31st of March.
Please take down. This matter appear under the heading of we mentioned. It appears that learned advocate for the appellant seeks for extension of interim order, which was earlier extended by this court on 24th of December 2024. It appears that with the order dated 8th of August 2024, this court has dismissed the appeal for default. All interim order passed by this court during the pendency of the second appeal has been vacated by the said order of dismissal. Now an application being can, what is the can number?
Can 4 and can 5, my lord.
Can 4
In SA2,
is placed on record for restoration of the appeal. The said can 4 is yet to be disposed of. Can 4 of 2024 is yet to be disposed of. However, by an order dated 22nd of August 2024, a coordinate bench of this court has passed an order of status quo till pendency of the can 5 of 2024. Full stop. It appears that an order of an interim order was extending time to time in an appeal which is not alive at all. Considering the situation, let the matter be placed under the heading of hearing, under the heading application, being can application for hearing. No, keep on. Under the heading of application for hearing, the application being can 5 of 2024. Next week, Friday.
Lord is fixing a date.
Next Friday.
Great.
Date.
Matter
Your lordship,
in the list on
your
4th.
lordship has extended.
Fourth,
Your lordship has extended the interim order for a limited period.
no.
Your lordship will kindly consider that we will be in great difficulty. We will come back on 4th and address your lordship.
Very well.
The
You come on 4th and I will pass out.
understanding before the coordinate
I
bench.
understand the earlier orders
Your
are bad
lordship
in law. You
will
know,
kindly
in the
take
appeal, which
this
is no
into
more,
consideration
you are
and extend this till 4th.
extending the interim order time to time. How can it be? Is it possible?
Yes. Your lordship, that was
Then
no, your lordship, I bow down, but it was solely done
you are
because
giving
the
blood
restoration
to a dead
application
person
was filed within time and it was
regularly.
simply.
Very well. Next. Let the person be revived.
My lord, in this matter, I am appearing on behalf of the respondent, my lord.
My lord, in
Which
this
for the
matter,
appellant.
my lord, Mr. Orijit Sarkar is appearing.
My lord, kindly see the order dated 27.
Why it is appearing under heading
Yes,
2 mentioned?
because till this day LCR has not come.
LCR has not reached.
No, my lord, kindly see the order dated 27 in November 2024, passed by the learned.
Let me see the report, what they have said.
Yes, yes. November 2024.
Which for the appellant.
My lord, Mr. Orijit Sarkar is appearing. Before my lord, Honorable Justice Shobhusachi Bhattacharya was appearing. After that, my lord, Mr. Orijit Sarkar is appearing.
I paid to cover LCR. I've already paid the special messenger cost. Kindly see order dated 27 November 2024. Kindly see, my lord. 27 November 2024. Landed court for 1 month. Thereafter,
27 November
2024.
2024.
Yes, ma'am. The order we can ask it.
Order book to khule den.
I have already given.
27 November 2024 is the order of learned register
Yes, he has
administration.
given liberty to move before the bench. Kindly see. Yes.
You are
Second,
for the appellant.
respondent, Miller. I am suffering.
Appellant has deposited the cost.
No, I have deposited. Sorry, Miller. It has been wrongly stated.
Special messenger cost has been deposited by the
I have
appellant.
deposited, Miller.
You have deposited.
Yes, Miller. For expediency. In view of the second page, kindly see. Till this date, this has not yet come. Despite of order, I have deposited special messenger cost.
Please take down. Instant matter appears under the heading of to be mentioned. Under the heading to be mentioned. Learned counsel for the parties submits that the instant appeal is pending since 2005. Both the parties are ready, but due to non-supply of non-production of trial court record, the appeal could not be heard out. It is the submission of the learned counsel for the respondent that he has already put in the special messenger cost with the department. Next, peruse the report submitted by the learned register administration within bracket L and OM. It appears that the though the intimation was served upon the learned court, being learned additional district and session judge 11th court Alipur, South 24 Parganas, no TCR has yet reached. Considering the situation, the learned register administration L and OM is directed to call for the LCR TCR, call for the TCR from the Office of the Learned Additional District and Session Judge, 11th Court, Alipur, through District Judge, through Learned District and Session Judge, Alipur, South 24 Parganas. The Learned District Judge is directed to take note of this matter, that this court is session over this matter, and he must ensure that the TCR must be reached to this court within 2 weeks from the date of receiving. Reach this court within 2 weeks from the date of receiving of this order. Learned Register, Learned Register Administration, L and OM, is directed to take appropriate steps to forward the copy of this order along with the intimation of this court to the Learned District and Session Judge, South 24 Parganas, Alipur, for proper compliance. Let the matter appear in the list on (25th of April) under the same heading.
And also, I pay to give liberty to the respondent to also communicate before the learned.
Parties are at liberty to communicate the order to the Learned Court. Parties are at liberty to communicate the order before the Learned Court. Next.
My lord, your lordship was pleased to pass this judgment on 20th of March 2025. My lord.
Yes.
My lord, there are some typographical mistakes only, which I may I kindly point out the mistakes.
Yes.
Not page no-
In the representation, who will be there? Learned advocate.
My name is Dhiman Roy.
Your name is
Dhiman Roy.
Dhiman Roy.
Dhiman Roy.
So Deep
Chondo.
not Dro, D-R-A.
D-A.
D-A, Chanda.
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 And my lord, the name of the appellant is Nagendranath Singho.
Nagendranath Singh is
Singho.
there.
No, Singh. It is
S-I-N-G-H-A.
G-H-A.
Okay.
Then my lord, page 4.
Page 4.
Hmm.
Yes.
My lord, the first para number 6. My lord, the middle, property plot number 17. My lord, it's plain reading what, my lord, it is, it should be plot area of 27 decimal.
They approach 20 for negotiation of sale of the property. Plot number 17.
If it is dag number, my lord, in Bengali, then my lord, dag number is 341 and 342. If it is Khotia,
So plot number is appear erroneously. Plot number
Yes.
17.
yes,
This matter should be cut out.
my lord, plot area of 27 decimal. That was the subject matter of the sale.
No. The sentence is the other. The
Sale.
approach 20 for negotiation of sale of the property.
Plot number 17, yes.
What is the plot number?
341 and 342.
Plot number should be
341 and 342. My lord, in Bengali, if we say it is a dag number, then dag number is 341 and 342.
that is the plot number.
That is the plot number, my lord.
So it is within invited comma 341,
And 342.
342. If it is come under
Khotian, my lord.
under the bracket, it will be better.
Yes.
It will be better.
Then, my lord, page number 5.
Page number 5.
First para, last but one line. Kho to Kho 3. It will
Not co.
not co because the co was
Co
the
is the
total
su-
property
KHA.
KHA and KHA3.
Yes.
Then my lord, page number 8.
Page number 8.
8. Second line from the top. Instead of 1988, it should be 1998.
It should be 1998.
98.
And
Then my lord, page number 11, para 9, para 19, last line.
yes,
Literate lady. Here it has become illiterate. Should be literate. Because they failed to prove her as a literate.
literate,
Literate,
not illiterate.
not illiterate. Now, page number 12, first para, last line, it's same. Should be literate.
No, appellant view that the style of handwriting of the appellant. Literate person, yes.
Literate. Now, page number 13, citation, second citation, it should be Madras 247, but it's not that, it has become MADRA.
S, miss the S.
Missed the S. Well, page number 16,
Yes,
para 29, third line. Instead of 24, 1985, the Orponnama deed was registered on 22/04, 1985.
22nd.
22nd.
Okay. Anything?
Yes, ma'am. Well, page number 18, para 35, last but one line. Literate.
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 Yes.
Well, these are the.
You just wait. Let me again serve one after another. Yes, please come. Please take down. This matter appears for correction of judgment of some typographical error of judgment dated 20th March 2025. In the first page, the cause title in respect of the appellant title, it should be read as Nagendranath Singho. Title should be read as Singho, SINGHA. Invert comma rakho. Instead of Singh, SINGH. In the list of representation of learned counsel, the title of learned counsel appearing on behalf of the appellant, Deep Chandra, CHADIP, Mr. Deep Chandra, should be read as Deep Chanda, CHANDA. Thereafter, page
4.
Page 4.
Plot number 17.
Okay. At page 4, at the 10th line from the top, plot number 17 would be omitted. Plot number 17 with that plot number 17 would be omitted. In its place, well, within bracket invert bracket. Plot number 341, comma 342, bracket close, should be inserted. Next,
at page 5.
Page 5.
First
Okay.
para, last
First
but one line. Khaw to
in
khaw.
the page, in page 5, so page 5, the last but one line of first paragraph, Kaw to Kaw 3, KA. এটা ইনফর্মের মধ্যে আছে KA to KA3 should be read as KHA to KHA by 3 by 3 এটা সব আগেরটা by 3 হবে ক by 3 হবে দুটো ইন্টারের মধ্যে রাখো next
Page 8, second line from the top.
in the page 8 at the second line from the top 1998 should be read as
98.
1988 should be read as 1990. Next,
My lord, page number 11.
page number 11.
Para 19, last line.
Para 19, last line. 19,
Literate.
last line. Para 19, at page number 11, paragraph 19, at the last line, literate. Illiterate should be read as literate. Illiterate, within inverted comma rakho, illiterate should be read as literate. Next,
Page 12. First para, last line, same.
at the page 12, first para, last line, the term illiterate within inverted comma rakho should be read as literate. Next,
Page
page
13.
13,
My lord, the
at
second
the second citation, the name of the High Court should be read as Madras, MADRAS, instead of MADRA. Next,
My lord, page 16.
next as page 16,
Para 29, third line.
at the third line of para 29, the date of execution of the Arpannama deed should be read as
22/04/85, 1985.
third line of para 29, the date of execution of Arpannama deed should be read as 22.04.1985 inverted comma দিয়ে রাখো instead of 20.04.1985. আচ্ছা তারপরে next,
My lord, page 18. Para 35, last but one line. It will be literate.
okay, at page 18 in the second line of paragraph 35, the term illiterate should be read as literate. inverted comma দিয়ে রাখো দুটোই, next,
My lord,
that's all. The office is directed to make out the corrections, the body of the judgment itself. Make out the typographical corrections in the body of the judgment itself within a fortnight.
আজকে কি নাম দিতে হবে? নাম কি দিতে হবে আজকে এখন? হ্যাঁ?
Next, who is appearing in the matter? আছে আজকে? This matter appear under the heading 2 events. None appears on behalf of the applicant stroke petitioner. Necessary direction has already been made to the learned Registrar General High Court Calcutta for disbursing the money. Let the matter go out of the list. Parties are at liberty to mention. Next.
No, item number 9, I am for the respondent number 1 and 2. Respondent number 1 and 2. The sole, the appellant, he died in 27th of December 2013. My lord, since he is my next door neighbor, I have come to know. But since I do not have the copy of the death certificate, for the purpose of mentioning the matter before your lordship, I sent a letter in my letterhead, and that letter has returned unserved as deceased. For proof of that, my lord, I have prepared an affidavit of service in that regard. But kindly have a look. This is a letter addressed to the appellant. And annexure is the copy of the letter which was sent to him. Page 3.
Yes.
So he is, my lord, and it is returned. My lord, kindly see the envelope on the reverse side. It is returned as deceased.
But when he has expired?
My instruction is the 27th of December 2023. I tried to serve this letter for mentioning notice upon the learned advocate who filed the appeal. But he refused to accept since he has no instruction. That could not be, because in 23 December, my lord, he is no more, my lord, it cannot be.
Please take down. Learned counsel appearing on behalf of the respondent submits that this matter appear under the heading to be mentioned at his instance. Before mentioning the matter, he has served registered notice upon the appellant personally. Full stop. The registered consignment has returned with a remark deceased.
The track record also shows the deceased.
Full stop. He has also placed the track record, which also shows that the appellant has expired.
Page 7.
Learned the affidavit of service filed on behalf of the petitioner, filed on behalf of the respondent is taken on record. Full stop. Learned counsel for the respondent submits that the appellant has expired in the month of December 2023. Since then, no steps has been taken. Full stop. Learned counsel for the respondent intends to serve the notice of mentioning upon the learned counsel for the appellant, but he did not take the notice as he has no instruction. Having heard the learned counsel for the respondent, also considering the remarks in the track record as well as the registered consignment, it appears that the instant is a sole appellant.
Murder is a sole appellant.
The sole appellant has already been expired. No steps has been taken by the appellants or his representative. Accordingly, the instant appeal has already been abated. Let the order of abatement be taken on record. The matter be go out of the list.
Only one indulgence, my lord. But they are enjoying the interim order of status quo, my lord.
Okay. Interim order, if any? No. The consequence. In the consequences of the fact that the order of abatement has already been taken on record, which is automatic in nature, the appeal has already been lost its force. So any interim order passed by this court during the pendency of the instant appeal is hereby also vacated.
And another indulgence is that the LCR has arrived. LCR should be sent back because it's a partition suit. They prayed for threefold relief in the suit.
What is the status of the?
Well, may I? Well, the suit was for three release, major three release. One is for declaration, one is for eviction in cause schedule, declaration in cause schedule, and partition in gauze schedule. but the learned court below initial, the trial court disallowed the first two, but allowed the suit for partition.
Okay.
They prefer the first appeal, title appeal. It was rejected. Thereafter, this is the second appeal. So, the partition should now it's should the preliminary degree has passed. So that
Final decree is going on.
it is to be because so the LCR should be sent back, my lord.
LCR, if received during the TCR, if received by this court during the pendency of the instant second appeal, be returned back to the learned court below. Immediate.
Even if special messenger is cost to be prepared, I'm ready to pay. Or kindly indicate, my lord, if the department requires any special messenger cost.
Not necessary, they will send it. Not necessary. Next. সবগুলো Friday কেন চলে আসে এখানে বলুন?
My lord, item number 10 was disposed by your lordship on 21st May 2024.
One was short. ঠিক আছে। তো এক তারিখ থেকে হবে। আচ্ছা, yes.
My lord, this appeal is disposed on 21st May 2024 by your lordship. This file, this is the insurance appeal. But my lord, some correction is required. It appears that the cost title of memorandum appeal that one of my claimant respondent number 2, Mohadev Shashmol, has wrongly written as Nohadev Shashmol by insurance company's advocate.
By that, why you are moving this court?
Because
There is
because your lordship direct to the advocate to the concert department correct the memorandum appeal in the department. Because
Where is the order?
Order, my lord, this appeal was disposed of.
So, that is why I'm asking. Why are you mentioning this matter before me? I don't have the determination of this matter.
My lord, this appeal was disposed of by your lordship.
Maybe
Be-
I have passed the several judgments. More
Yes,
than
but
1,000 judgments I have passed in the MSCC appeal. So all the matter will appear before this court.
no,
Now what you want?
I want
The designated bench. You can move this matter for minor corrections. Minor corrections you are appearing before this court. I don't have the determination now.
yes, lordship,
Then-
but there is no application, only some direction, but
So specified bench is there.
specific bench is there, but
what?
My lord, Ononya Bandopathy not.
No. Please take down.
My lord, kindly give us some order to liberty that the correction will be in the advocate in the department.
No. You take the order from the appropriate bench. I don't have the determination to do this matter. This is an appeal in connection with insurance. This is an FMAT. In connection with insurance appeal. This court don't have the determination to deal with the FMAT in connection with the claims, in connection with the motor accident claims. After the matter be released, the learned counsel for the petitioner stroke appellant is instructed to approach the appropriate bench for desired relief. Next. Eleven and 12.
My lord, item number 1112 was mentioned by Mr. Chatterjee. The order.
দেখে দিয়েছেন বলুন দেখি। হ্যাঁ কি লিস্ট এটা appropriate bench চলে তো বলেছি আমি। আমার কাছে নেই আর আপনি এখানে বসে থাকবেন। Before the appropriate bench, then এমন সব করেন না অন্য কাজ সব আটকে যায় আমাদের সব কাজের কোনো দরকার নেই না আমার ডিটারমিনেশন আমি করবো না yes what can be done now
My lord, let it be placed before the regular bench.
yes that is the order is there specific order is there
My lord, that was my humble submission before your lordship, my lord, that firstly, my lord, there was a application already filed. So extension would not be an issue on that date. But since your lordship is releasing the matter, your lordship can very well direct them to place this matter immediately on the next date, whatever will be the available
My lord,
date.
till then there is, my lord, till then the stay should
Then
be there.
apprehension for arrest till then.
Yes, my lord.
My lord, on last
Warrant
occasion,
has been issued, my lord.
the warrant has been issued in the month of September 2024, my lord.
It was the order of stay is there.
Yes,
Order
my
of
lord,
stay
but
was-
till
that
today, my lord.
Order of stay, if your lordship sees, your lordship was pleased to pass it on 6th of March. That was valid till today. Now, my lord, the issue is this, my lord, that on last occasion also there was a non-execution report. The non-execution report was submitted. They did not bother to inform anything before the landed court that your lordship was pleased to pass an order for stay or something like this, my lord. So I do not feel that dying urgency in the matter, that if it is placed before the regular page on Tuesday or Wednesday, whatever is will be the next available date, there will be any apprehension.
My lord, let them give an undertaking in the court, my lord, that they will not take any steps.
This is the undertaking.
My lord, Mr. Chatterjee has already submitted, my lord, in the
Very
morning.
hard.
Till Wednesday, my lord, if you
How
can.
Mr. Laird can give the undertaking. It is the executing.
My lord, they are
authority
saying
there.
they will not take any steps, my
But we
lord.
have
Executing
not.
authority is
Yes,
the-
my lord.
If we had taken any step, then on present.
That is the
on
difficulty, my
on
lord.
submission of the
He
non-executive.
cannot
Mr.
do
Laird
anything, my
or
lord.
his client has no act to do.
Madam,
The action
if
is the
we-
authority.
Yes,
My
my
lord,
lord,
if
that is
we
the
had-
difficulty.
If we had been so overzealous, then on the submission of non-execution report, in spite of this order passed by this court, we could have filed an application for Tagid.
Yes.
That we have not done because we have the respect for the honorable court.
Very well. Very. Okay.
My lord, till
Please
Wednesday.
take down in both the matters. What will be the next date? Wednesday.
Yes, my lord.
My lord, next day before
Monday
the-
is holiday, my lord. Tuesday, I don't know whether they will place it or not.
My lord, next day before the lower court is on 10th of April.
No, no.
No, no.
Next day before the appropriate bench.
Before the appropriate bench, my lord, it may be Monday if it is not declared holiday. If it is declared holiday, it will be on Tuesday.
Tuesday.
My lord, that is any day between Monday and Tuesday, it will be.
So it would be better to come to second. Wednesday.
Yes, yes, my lord.
Wednesday. Full stop.
Second is Wednesday.
This
no?
court
Hmm.
has passed an interim order in connection with CRAN 1 of 2025 on 6th of March 2025. Full stop. By passing that order, this court has directed the matter should be appear before the appropriate bench on
20.
March 28th. Stop. March 28, 2025. Erroneously, this matter appears in the list of this court. Learned counsel appearing on behalf of the petitioner within bracket CRAN 1 of 2025 seeks necessary accommodation so that till the matter be appear before the appropriate bench, the interim order passed by this court on 6th of March 2025 be extended.
Yeah.
Having heard learned counsels for the parties, it appears that presently this court has no determination to deal with this matter. However, as this court has passed an order, as this court has passed an interim order, so I think it justified to place the matter before the appropriate bench on second day of April 2025. Till then, the interim order passed by this court on 6th of March 2025 shall be extended.
My lord, if your lordship be kind
Release
enough,
the matter immediately.
my lord, if your lordship kind enough to record one line that I have raised objection regarding extension.
Mr. Lahadi, learned counsel appearing on behalf of the opposite party, raised strong objection for issuance of for extension of any interim order. But again,
Extremely grateful.
Grateful, your lordship.
Extremely grateful.
দুটো এখনই পাঠান order করে দিন। Next,
My lord, just one indulgence in Monday can be a holiday, my lord. So if they can upload it today, then we
today
will.
I release the matter. Today,
Grateful, your lordship.
call the matter.
My lord, in this matter, I am for the respondent. But I am practicing here near about 38 years. But one thing, my lord, we are learning every day by way of supplementary affidavit, amended the pleading. Is it permissible in the eye of law? I am asking myself. Now my learned friend served a copy upon me, supplementary affidavit. On the ground, some correction in the pleading be corrected. Is it permissible? Even if the application which was filed initially that day, your lordship asked my learned friend, yes, it should be reaffirmed. Because in the affidavit portion, the appellant number 1 stated, I on behalf of the appellant number 2, well accounted and affirm this affidavit. Your lordship asked my learned friend, yes, it should be reaffirmed. That was not done. Now my learned friend served a copy of supplementary affidavit. On the ground, the pleading which was taken in the application which was filed before your lordship, some portion be corrected and it was erroneously pleaded my client. It should be corrected. Nowhere in the plaint this fact was not corroborated. So now I am praying before your lordship, as your lordship desire, I will file affidavit against the supplementary affidavit. And earlier occasion, I have filed opposition stating that the application is not informed because the affidavit portion is bogus, is wrong. Supreme Court says, yes, he can file, but it should be reaffirmed. That portion should be deleted by the applicant, but they have not done so as yet.
So what is the application?
For appropriate order for expunging the name of the deceased who died in the year 1997. Now the appellant number stated that I am the sole appellant, but in every occasion he filed an application as a sole.
Let me hear it out from the.
Yes, as your lordship desire, but
I shall hear you.
The correction should be made first.
I shall hear you. No issue.
No, the application is not maintainable.
Where is the application? Application.
Can 8. Three applications are there. Can 8 is the one. Kindly take up Can 8. Can 8, Can 9, or Can 10. 3 matters, ma'am. 3 applications. Can 8 is, my lord, application for appropriate order on the date of the plaintiff number 2 as well as the appellant number 2.
Can 8 is the application for appropriate order?
Yes, it is the application for appropriate order. My lord, the advocate change. My lord, the Borun Das was, my lord, plaintiff number 2, and my lord, he is the appellant number 2 here before your lordship. He has died. My lord, no application for substitution was filed. My lord, I have taken the point. It is at paragraph 4 onwards, page 3, paragraph 4, that it appears from the record that the appellant number 2 died on 6th of July 1997, leaving behind his father, Boshanto Das, who was, my lord, the sole respondent. He has died, and on his death, my lord, his heirs have already been substituted. They are already on record. Therefore, my lord, I have prayed that since the heirs are already on record, therefore, no necessary, there is no need, my lord, to file an application for substitution. His name may be deleted from the record.
That is the respondent number 2.
No.
Appellant number 2.
Appellant number 2. My lord, actually, appellant number 2 is the, my lord, biological son of the respondent. But all along, he has, my lord, taken care by the appellant. Therefore, my lord, suit was filed by the appellant, both the appellants. Appellant number 1 is the brother of the respondent.
I understand.
But since the son of the respondent was residing with me, I have taken care for him, my lord. He has also joined me in the suit as well as in the appeal. Now, my lord, he has died. My lord, my respectful submission in the application, it was stated that his legal years are already on record because on the date of Bashanto, the respondent, but my lord, in the supplementary affidavit, I have stated that in the earlier application, when my lord,
Where is the supplementary?
my lord, this is the supplementary affidavit, my lord. Today I am filing this. My lord, supplementary affidavit, my learned senior friend has stated that it cannot be maintained, it cannot be entertained. Supplementary affidavit is nothing but, my lord, application for amendment. My lord, what I have stated in the supplementary affidavit, that in the earlier application, on the date of Bashanto, the respondent, my lord, the years were, my lord, written that the, my lord, if your lordship's kindly taken up can 5, which has already been disposed of. Here, my lord, the years of Bashanto was mentioned as Dipu, Somir, Kalo, and Shantai Das. Therefore, my lord, the plaintiff appellant number 2 has not been described as the years. Actually, my lord, it was understanding. There is no document on that. The appellant number 1 adopted him.
So what is the
What is the
purpose
situation
of
maybe?
supplementary affidavit?
Well, only to state that the appellant number 1 is the heirs of the appellant number 2 because he is the adopted father. That I have stated in the supplementary affidavit. But my lord, what I am submitting now before your lordship, my lord, the issue involved in the appeal.
Whether the adoption is in the issue?
No. Whoever may
Who
be
is the biological father of appellant number 2, respondent. Respondent expired.
His
on,
heirs
on
have,
his death, all the heirs are substituted.
but at that time, my lord, the plaintiff number 2, the appellant number 2 was not, my lord, described as the heir of Bashanto.
Whatever may be. So what you want to
now, my lord, what I am submitting here, so all the application may be disposed of, all 8, 9, and 10. My lord, so for 8, my application for
expunging the name of
the appellant number 2.
Okay.
Because heirs are already on record. My lord, whoever may be the appellant who is the adopted father, maybe the respondents who are the son of the biological father, whoever may be, I have no objection to that. And my lord, another application has been filed by my lord senior friend that he has stated, my lord, it is order 22 rule 5, stating that since there is some dispute, my lord, in that application, one lady has been, my lord, introduced who is claiming that he is the
just wait. Let me finish one after another.
Yes.
So
actually, my lord, all 3 applications on the same issue. All 3 applications on the same issue.
Why? Can 8, can 7?
Can 7,
Can 7 is for
no,
what?
my lord, can 8, my lord has taken. Can 9 is, my lord, on order 22 rule 5.
Not 22 rule 5, can 9.
Can 9. It is stated that since it is dispute, it should be sent back to the trial court for determination who is the legal heir. My lord, I am not disputing. Let the, my lord, the lady which has been mentioned in this application be added as
lady came. Where from lady came? What is
my lord, he has filed the application.
This is the application can 9. This is your application.
Can 9 is filed by my learned friend.
My application. Your application.
My
22 rule 5.
my lord, page 4, paragraph 2(1). Page 2, paragraph 2(1). My lord has got it. Page 4, paragraph 2(1). Bina Das Mondal, wife of Borun Das. Well, therefore, this lady has come claiming that he is the wife of the appellant number 2. Let her be added. I have no objection because my lord, the issue is very simple. Whether the appellant has paid the considered money or the respondent, the original defendant has paid the respondent. Who has paid the consideration price, he will get the property.
That is not a question here.
That is the question involved in the appeal.
I am not going to the merit of this appeal. Let me dispose of the application.
Yes, my lord, kindly dispose of all the applications.
So, you don't have any objection in respect of can 9?
No. Let her be added.
Let her be added as a party.
Subject to correction, my lord.
He has prayed for
the application for the addition of parties.
No.
What is your
Give me
application?
chance. Kindly give me chance. Why I have filed order 22 rule 5? Because
only to delay.
No, certainly not.
So what is your prayer in the
prayer is, my lord, as and when the dispute regarding the heirs and legal representative.
I am not raising any dispute.
Order 22 rule 5. It is the duty of the appeal court to remand the matter for a limited point. The wife, the lady is a wife. He knows everything. He knows everything. 1997, the Borun Das died. In the plain nowhere stated. In the plain nowhere stated the Borun Das is the adopted son. Now they have taken the plea that he is the adopted son and he is the biological son of the Basanto Das, defendant number 1. Now my question is, as and when the dispute regarding the airship, the Supreme Court says,
But
it
I
is
am
the
not
appeal court then for a limited period upon the trial court to ascertain whether who is the heirs and legal liberty. Because now they are clevering the say the appeal has already been wholly abated because it is a joint degree. It is not an individual degree. Supreme Court says, as and when one appellant died long before, if the appellant number has not taken any step for substitution.
Have you read Order 20 Rule 5?
Yes, I have read. Proviso is there.
Has not raised any question.
I am not disputing. Let her
He
be
is
added.
not disputing. Let
Sir.
her added as a party.
Party, but the limitation is question. Mayor party is not a, who is the necessary party? Your lordship and enough experience. My contention is, he is the heirs and legality of Borun Das.
I shall
Let
hear
me
it
finish.
out.
Let me finish. Supreme Court says, I will file the Supreme Court decision. Your lordship controversy the same. Yes, it is the
You file-
bogus
you file.
decision of
Give
the
me-
apex court.
Give me the file. Give me the.
Yes, I'll give. But I may be permitted to file supplementary affidavit because they have erroneously stated that it is a erroneous. Is it permissible in the eye of law? Your lordship has enough experience. Amendment application order 6 rule 17 is applicable. No supplementary affidavit. Supplementary
No, no,
affidavit.
I am with him.
Subsequent event.
I am not pressing the supplementary evidence. All right, I am not pressing the supplementary.
Yes. Then
I am very much interested to hearing of the appeal.
yes, I am ready. But order 20 to rule 5.
Order 20 Rule 5,
not
what it
disputing.
says,
Yes.
he is not disputing. He is
But
not
no,
disputing
no,
your
no,
input.
my lord, I am praying before your lordship. Order 20 to rule 5, it is not a mere addition. Dispute is appellant says.
No, no.
Appellant number says.
You just read Order 20 Rule 4.
Yes.
Thereafter 5.
5.
Thereafter 5. Rule
Yes.
4 and 5. Is read all together.
Huh.
If there is a dispute regarding the airship, then the matter can be.
They have raised question. They have raised question.
They have not
Yes,
raising any
yes,
question.
and see, in the affidavit taken.
They are not raising any question.
Right now, I am not raising any question. Let her
They are
be
not
added.
raising any question.
Let her
Now,
substitute.
No.
what no?
Very easy to say, let her be added. Then limitation point.
No question of
abatement
limitation.
point.
Other years are already on record. It
You
may be
don't
irregular.
want to add her a party.
Yes. But
Then
the
why you
adult-
want to delay the matter?
No, I am not dealing. Kindly think over the matter. Kindly think over the matter. Regarding the point arise, whether the appeal abated or not. This is the question.
Other years are already on record. No
No.
question of abatement.
No.
It may be irregular.
The Borun Das married person, his wife is alive. So within the time,
You file specific question.
your lordship can prejudging the matter, then your lordship release the matter. I will not get justice from you.
এরকম করে কি আছে?
Yes, certainly.
মানে
Your lordship can give the justice.
Very well.
Your lordship cannot understood the same.
If you are not ready to deal with this matter,
Ah.
then I will release the matter.
Yes,
in that
release the
event,
matter.
I shall suffer.
I will go elsewhere. I will get justice on another court.
Very good.
Yes.
In this way, my
Your
lord,
lordship kindly not understood the abatement. Your lordship kindly adding and abatement is different.
আরে আমি নয়।
Adding and abatement are different.
Have you filed any application?
Yes.
What application you have
Kindly
filed?
see, order 22 rule 5.
Yes,
Yes.
you filed the application and praying for a prayer. Prayed
Yeah.
for a prayer.
Huh?
I will dispose of the application.
What application?
Your
lordship
application.
kindly ask me only. Why you asking? Why you laughing? You know, order 22 rule 5. Dispute arises. They told the boss of
They have not raised any dispute.
Adding no addition is the abatement is question is there. 1997 the appellant was died.
No, you are not ready to do the
I am
matter.
ready. Your lordship can release the matter.
Yes, that would be better.
Certainly.
That
I
is
will not
better.
get justice. Your lordship can
Very good, very good.
record the order.
But it is part-hard matter, my lord, in this way, if it is.
No.
No.
That cannot be done like that. He is not ready to do the matter with me.
I am ready, but your lordship not ready.
No, I am ready.
No.
However, you are not ready to.
Abatement is question is very much.
Where you have raised that question?
Abatement.
Very good, very good. Please take down. Just wait.
So for abatement, he has not filed any application
Okay,
for
okay,
recording
okay. I am
abatement.
not taking time.
He has not filed any objection to my application.
Learned counsel appearing on behalf of the respondent not intend to proceed with this matter.
No.
Before this,
My submission otherwise.
before this court, before this court,
Before this court.
before this court.
No, no, no. Hello. My lord, kindly record the
Let
same.
the matter be released.
As and when I have made, your lordship deny the same. Abatement and additional party are different. And see,
Okay, I am released the matter.
yes, certainly. That is why not.
Okay, okay.
Yes, I'll go to the Supreme Court.
Yes,
Yes.
go to the Supreme.
হ্যাঁ যাবোই তো এই জন্য তো এখন পর্যন্ত এখন হয়
Next,
ইয়েস
next.
ওই জন্য তো অ্যাপয়েন্টমেন্ট এখন হয়নি
বলছেন
তাহলে অ্যাপয়েন্টমেন্ট আর অ্যাকশন করে কি
একদম ঠিক বলেন এটা করতে আপনি করতে পারেন বাইরে গিয়ে করে বাইরে যান করে আপনি করতে পারেন
No, no, just forget it. This is nothing a matter. This is nothing. Just wait. This is, no, this is nothing a matter.
tomorrow my lord a junior member will do it
This is nothing a matter. You just wait. This is nothing a matter. No, no, just wait. And this is not it. This is not an issue. He is not ready to do the matter. Release it.
but he has to keep his mouth shut if he is not ready there are ways and means of saying
No,
this is the high court
forget. Some persons are not ready to do a matter. So what can be done? No, yes.
that's a different thing my lord before the honorable high court he can't treat it like a park he can come in and say whatever he wants to
Yes. This is the situation now.
কি দিনকাল পড়ে গেছে যা ইচ্ছে তাই বলছে দাঁড়িয়ে মুখের সামনে শুনতে হবে বসে
And this is the application for substitution after setting aside amendment and application under section 5 for condemnation.
Item number?
Item number 14.
Item number 14. Yes, who are you?
I am the appellant.
You are the appellant petitioner. How many applications are there?
22 applications. 7% died.
11% died. Have you served those applications?
No, my lord, without order, I cannot serve.
You served them.
What
Uh,
order? Serve the copy.
How many applications are there? Application
22. From 2 to 23.
can 2 to
And 2 to 23.
very well. Okay. Please take down.
My lord, principal opposite party, number 1.
Principal.
Otherwise, pro forma respondent.
Now you are the appellant.
I am the appellant.
So state of West Bengal is the respondent. Okay. Can 2 of 2025 take a can 23 of 2025. Okay. These are the applications for substitution filed by the
Appellant petitioner.
appellant petitioner. The appellant petitioner is directed to serve the application upon the respondent.
Principal respondent opposite party.
Answering respondent. Answering stroke principal respondent. And file an affidavit of service on the returnable date. Let the matter appear in the list. Okay. না ঠিক আছে তাহলে করুন কি বললাম let the matter go out of the list parties are liberty to mention you are liberty to mention after service yes
Lordship, I am for the petitioner.
Yes.
Mr. Joyanta Samanto is instruction me. All
Which are
the
the respondent? What
all
is
the-
the application?
all the applications are completed. Kindly,
All
Lords,
the applications?
all the applications are completed. No pending.
All disposed of?
Yes, Lordship.
So why it is appearing under the heading application?
Is kindly, Lordship, kindly is hearing it.
Learned counsel for the, please take down. Learned counsel for the appellant submits that. This matters. Now all the applications has disposed of. The matter is otherwise ready for hearing. Let the matter be listed under the heading hearing. Next.
Well, I'm for the petitioner here, but appearing for the unfortunate respondent.
Going on in another court. His reason I am paying for not.
Well, this
So
is
many
the-
applications are pending.
No. Application. But this is my affidavit of service. I'm order কিছু নিচ্ছি না, just sorry for- This is affidavit of service. My lord, on 14th of February, the matter was due to appear. And before that, 13th of February, I have served a copy of my opposition against his application under section 5, which was filed after 5 years. Now, my lord, what happened on 14th? What happened on 14, my lord, in the regular list matter was not there. It was mentioned at 3 minutes past 11. After so then, my lord, it was mentioned by my learned friend, it was added in the supplementary list.
It was not mentioned by him.
Whatever it might be.
It was never mentioned by
No, it was not mentioned by him, but it was in the supplementary list. I don't know how. Anyway, whatever it might be. But the matter was heard is part. So I'm praying, let it be heard. I'm here.
May I just indicate to your lordship? This is an application for restoration.
আমাকে একটু বলতে দাও ভাই, আমাকে একটু বলতে দাও ভাই, আমি বুড়ো মানুষটা একটু বলে নি। My lord, in March 1919, my lord, the appeal was dismissed for default after notice to the learned advocate for the appellant, as per order of Justice Vivek Chaudhary, as his lordship then was at that point of time. My lord, appeal cannot be heard on merit if the appellant is absent, and according to order 41, so that appeal was dismissed for default. That was in March 1919. My lord, in 21 December, like that, my lord, one application for restoration was filed without service of any copy to me. Well, after 2 years, then, my lord, after 3 years, section 5 application filed in 24.
Okay.
So, 2019 order is, my lord, being set aside, we are praying for having it set aside after 5 years, and, my lord, I could not have the opportunity of placing my case, placing my argument on that. Though I have served a copy of the opposition just before on 13th, he knew that I am appearing.
That is the order.
Order was passed on, my lord, on 14th of February. Well, let me be hard, my lord. I want that, my lord, and nothing more. Order, 14th of February. Order. I am not blaming anybody, my lord. I am blaming my luck, my lord.
Order,
Let me be hard, my lord.
order dated
14th of February this year.
14th of February.
Right.
That is good. Order 2.
My lord, can you hear me? Then, my lord, after your order may be passed, I will have no grievance. I think my learned friend will not stand in the way.
It has been submitted. It has been
Merit
referred,
judge,
referred.
merit judge, merit judge.
Some fraud has been practiced by the advocate with the lordship. With the lordship.
He should have intimated your
But
lordship.
contact, my
Just a minute.
From the abatement, I should be
My lord, at this stage, I'm not ready to hear anything on my conduct. My lord. Tomorrow I may die, my lord. I'm running 80 now. At this age, after 55 years of practice, I am not in a position to hear this.
But the appellant has practiced fraud.
Yes, because his duty was to draw your lordship attention that
Let
I
me
have
find
received
out the order first.
opposition yesterday, and somebody is appearing. Then your lordship, I believe, you did not.
I have not practiced any fraud. Your lordship's order was kindly see the lordship's order 24th of January 2025. My lord directed me to serve the copy of the restoration along with section 5.
I've got it.
It was made returnable on 14th February 2025.
Right.
On the returnable date, my lord has fixed several matters which were made in the entry of the diaries by the my lord's office. None of the matters which were fixed on 14th February by your lordship on the previous dates did not appear. My lord's officer Suomoto published a supplementary list, and it was published in the official website of the Calcutta High Court.
14th of February.
14th of February, my lord. On that day, my lord, swearing of Justice Chaitanya Chatterjee was there.
24th January, your lordship was pleased.
Just wait. In the first hour, your lordships are busy for the swearing ceremony. So thereafter, your lordship sat and passed the order, and list was published on 3 minutes past 11. I've annexed everything. 11. So I could not follow up that matter. Well, Lord,
just indicate, my lord,
and Lord,
when a question of fraud has been made,
before that day, just a minute.
What fraud I have committed?
I'm saying, what is the fraud? My lord, if I am here, if your lordship asked me what is the other side, I should have said that yesterday I received the opposition, somebody is there. Then I believe your lordship would have fixed the matter next day and asked my
your lordship to publish the supplementary list. It is your lordship's own officers on own accord printed the supplementary list because several matters fixed on 14th February was not listed. And my matter was one of them.
If that be so, that cannot be constituted as a notice. Nowadays, when the clients have
the copy of the order.
Why not kindly see the order?
Yes.
And kindly see the order of 24th
Order I managed
24th January.
with the application. With the application.
Order book koi.
What do you want to say? I should not be heard. Then I am going, my lord, out. If he says that I should not be heard, my lord, I am going out. I am going out.
I would have not been saying this thing. It is the fraud to which an allegation of fraud has been made against a lawyer.
No, 14th February was the date fixed for hearing.
14th February was
due to appear.
Returnable date due to appear. On 24th of January, your lordship was pleased to pass an order directing the appellant
To serve the application.
Yes, I have served. Application is prepared.
Okay,
Now,
14th.
pursuant to the service of both the application on the restoration and section 5, my landlord made filed an written objection to it. Serve the copy upon me.
Right.
So you were not there on
14th, I was not there. I could not follow the list, my lord.
On the returnable
supplementary
date, when the matter did not appear before your lordship, the supplementary list was prepared by your lordship to officers on the said date, where nearly 6 matters were made published. Kindly see the supplementary list. I am handing over the copy.
Yes, give me the
I've annexed the application. I've
Now,
annexed everything.
my matter appears as serial number.
Yes, I annexed.
Which has been published by my lord's officer.
Well,
and I followed from the official website. When I came to know that such a list has been published, immediately I came here. I appeared. My landed friend did not appear. I followed the list on the website. I appeared before your lordship, made my submission. Your lordship was pleased to grant the restoration.
My lord, that supplementary list cannot be called as a public notice because clients are also following, my lord. Clients are also following. In the morning, my client informed me that the matter is not appearing. I also checked the matter is not appearing.
12 and 13 of the application.
So your application is for recalling that order.
My lord, can you hear me and pass the order? I want that, my lord. Nothing more.
If a client.
He's like my son. I knew his father. He's like my son. I love him.
No,
He
that
should
is not the issue.
shout like so much.
Father, we kindly considers the abatement made in paragraph 12 and 13.
His father was a very good friend of mine.
That should be expunged. Paragraph
Very well. I will not take care of.
My lord, can you hear me?
But allegation of fraud being made, what should fraud have acted up?
As an advocate, as I understand, my friend, it was your duty to inform the honorable judge. No, it's the honorable judge that I have received the copy from other side. All right, I kindly take up tomorrow. I will inform him.
Now, my lord,
It is not the regular list. It's supplementary list.
Kindly file a can 7 of 2025 affirmed by my landed friends client.
Can 7.
Can 7.
Paragraph 10.
Paragraph 12, I am placing my paragraph 12 and 13 where the allegation
No,
of fraud
10 onwards. 10 onwards. 10 onwards.
Give me can 7. Can 7.
কোনে থাকবে এবার রাজা ওইটি ক্যান্সেলমেন্টে হিয়ারিং হচ্ছে ওইটি হিয়ারিং
Kindly see pad.
10 onwards for 10 onwards. My lord, can you have my copy and let it be find out? Copy. My lord, can you take up my copy? Can you ignore the marking? My lord.
সবগুলোকে শোকজ
Let it be found out and
can 7 is appearing in the list. Where is can 7? কোথায় ফাইল can 7 বের করুন
এখানে দিলে হবে 7 এ 8টা
সবগুলো আপনারা শোকজ না হলে কিন্তু খুব বিপদ হবে
Kindly text paragraph 7, paragraph 10. As awarded my landed friend appearing for the respondent, petitioner in this second application.
Yes.
On 14th February 2025, the matter did not appear in the regular list of Honorable Justice due to swearing ceremony of Honorable Justice Chaitanya Chatterjee Das on 14th February 2025. The Honorable Court sat little after the scheduled time of commencement of the Honorable Court's business. A supplementary list containing certain matters were published on 11.3 a.m. On 14th February 2025 in respect of court number 24, wherein the Honorable Justice Samanto was and still now sitting. The application were included in the supplementary list at the instance of the landed advocate on record for the appellate. Kindly take note of. This is an aspersion against me. I have never mentioned those 7 matters which appeared in the supplementary list were included in the diary of your.
So far I understand. So far I understand, my lord. The extremely urgent matters are being added in the supplementary.
I have never mentioned.
Very
The officers that I came to know.
I'll take the matter.
Now we come to paragraph 13. What have you said against me?
Allegation against you.
Kindly see paragraph 12.
Yes, allegation only for the reason
those who application by suppressing the pad.
Yes.
What is the suppression of pad? If I put the question to myself.
Yes.
That he had already received the affidavits from the plaintiff respondent and despite having been aware of the appearance of the Honorable Court, was made to believe that the plaintiff respondent did not appear despite serving. Such conduct of the landed advocate on record for the appellant is matter of gross misconduct.
Yes, ma'am.
Such a conduct on the part of the landed advocate on record for the appellant amounts to fraudulent act, and such an act led to the Honorable Court to commit a mistake prejudicial interest of the respondent plaintiff. The matter further submitted that the order was passed in ignorance of the fact of the appellant respondent has not been informed and or notified regarding the urgent listing of the application in supplementary petition 14 February 2025. It was the duty of the landed advocate of the record for the appellant to intimate and notify the landed advocate for the respondent plaintiff before bringing the application in the supplementary, which he did not do deliberate. Now, kindly, I put the question to myself. My lord officer was posted.
My lord, I may be hanged, my lord. I may be hanged. What can be done?
What made my lord?
Now I have attained the age of 5 days. 8
I understand your
years.
submission.
I may be hanged, my lord.
I understand your submission.
Let us go to the merit of the matter. তোমার ভাই জানানো ছিল যে
আমি স্যার নিজেই জেনেছি যখন ওয়েবসাইটে বেরিয়েছে।
না সে কথা না।
আমি সঙ্গে ছুটে
আমি বলছি শোনো বাবা, আমি বলছি যখন লিস্টে ম্যাটারটা এলো তুমি তো জানো আমি অ্যাপিয়ার করছি।
আরে আমি সঙ্গে এসেছি।
তো তুই জজকে বলা যে মাই লর্ড অ্যাপিয়ার করছেন আদার সাইড, আমি নোটিশ দিয়ে জানিয়ে দিচ্ছি। আমি অপোজিশন রিসিভ করেছি আগের দিন। এটা বললি তো ঝামেলাটা চুকে যেত।
So in respect,
হাইকোর্টে আছি।
in respect of can 5.
We are the best advocates in the state.
Can 5.
Can 5 and 6. 5 and 6.
My lord, may kindly consider the order passed by your lordship. My lord, copy I have handed over. I don't have any spare copy.
But I'm not against the order, my lord. I'm not, my lord, let me be hard. I want to place my case. You will also hear me, then pass the appropriate order. No question.
Kindly see the order passed by your lordship on 14th February 2000. Yes.
Full.
My lord, my lord, I passed this order. Can 5 of 2021 is an application for restoration of the second appeal which was dismissed for default on 5th March 2019. Can 6 is an application under Section 5 of the Limitation Act for continuation of delay in preferring Can 5 of 2021. Can 5 is not on record. Department is directed to place Can 5 of 2021. Copy of the Can 5 be handed over by the learned advocate for the appellant. Let the copy be taken on record. But that Can 5 was not on record. I handed over my copy. Your lordship, sorry. Pursuant to the direction of this court, appellant was served the copy of the Can 5 of the 2021 as well as Can 6 of 2025 upon the respondent. Appellant was service filed by the appellant is taken on record. It appears from the applicant service that the service of the contested respondent number 1 and 2 is completed. Despite service, none appears for the respondent. Learned advocate for the appellant submits that the application in Can 6 of 2025 has been filed for by a delay of 994 days. It is submitted that the appellant is an old lady. Her husband used to look after the second appeal. Her husband expired in the year 1997. Since then, she was dependent upon the learned.
97, 97, 17, ওটা ভুল হয়েছে।
Since then, she was dependent
1917.
upon the appellant to conduct the instant second appeal. It is the case of the appellant that on March 5th, 2019, when the matter was called, the learned counsel for the appellant was not present as he was suffering from viral fever. He further submitted that due to the absence of the learned counsel, this court has dismissed the second appeal for default on March 5th, 2019. He further submitted that the appellant could not take proper steps for restoration of the appeal to her personal ailment in the entire period of time. She was admitted to several hospitals undergoing several surgeries. She prayed for necessary orders for restoration of the second appeal. Had the learned counsel produced the application on Can 6 of 2025, annexure of the application contains several medical documents wherefrom it appears the appellant is an old lady and was suffering from severe.
Those are misleading. I will submit on that.
It further appears that she was admitted different hospital and undergo surgery during that meeting. Considering the entire aspect, it appears to me that the appellant has demonstrated some sufficient reason for not preferring the application in Can 5 of the 2021 within statutory. Considering the same thing for causing the delay appears to be sufficient and the same is thereby accepted. Accordingly, the application in Can 6 of 2025 is considered and allowed. Delay preferring the application in Can 5 is hereby controlled. Can 6 is disposed of. Now, in regarding to Can 5 of 2021, this is an application for restoration of the second appeal by setting aside the order dated 5th of March 2019. It appears that the delay in filing the instant application has already been condoned in pursuant to Can 6 of 2025. Accordingly, the application in Can 5 of 2021 is considered and allowed. The order of dismissal passed by this court on 5th March 2019 is hereby recalled. Second appeal hereby restored to its original file and number. Accordingly, Can 5 is disposed.
Okay.
But this is on the basis of the application in my restoration application that was filed by the Ashby.
My lord, can you hear me? I'm not on the merit of the order.
Admittedly, the respondent was not there.
My lord, can you hear me and pass the order?
So it is fact that the list was prepared after the regular list. So let the matter be heard again.
My lord, on 1,000 days delay. And it was filed after 5 years.
Very. You have to give it a chance to. Okay.
Kindly hear me, my lord.
Can 7.
Can 7. Now Can 7.
Now Can 7.
Your lordship is hearing Can 7.
Please take down. Can 7 of 2025. This is an application filed by the respondent for recalling the order of this court dated 14th of February 2025 in respect of Can 5 and Can 6 of 2025. Learned counsel for the respondent submits that both the applications being Can 6, Can 5 of 2021 and Can 6 of 2025 was served upon him. He used the affidavit against Can 6 of 2025, but on the day when the matter was fixed for hearing, that is on 14th of February 2025. That is on 14th of February 2025. The regular list was not prepared in respect of the second appeal, being SA 472 of 1996, along with the connected applications. But later, a supplementary list was prepared and the matter was heard. Learned counsel for the next one. Learned counsel, the respondent submits that he was not present at the time, so he need necessary order for recalling the order dated 14th February 2025, so that he may be given an opportunity. 14th February 2025. So, so that may be given an opportunity to place his case, place his objection in respect of Can 5 of 2021 as well as Can 6 of 2025. Learned counsel appearing on behalf of the appellant submits that some aspersion was made against the learned counsel for the appellant in the applications being Can 7 of 2025. Application being Can 7 of 2025. The aspersions are false and fictitious. Having heard the learned counsel for the parties, it appears to me that it is true the second appeal being SA 427 of 1996 was not listed, was not in regular list for the day, that is 14th of February 2025, including some other matter which were fixed for hearing. However, the officer of this court found that altogether 6 matters were missed for regular listing. Thus, a supplementary list was prepared. The supplementary full stop. Supplementary list was prepared on 14th of February 2025. It is true that the learned counsel for the appellant has no role to play in listing the instant appeal in the supplementary list. Accordingly, the aspersion made against the learned counsel for the appellant in Can 7 of 2025 appears to be not justified. However, as the learned counsel, as the respondent was not heard on 14th of February 2025 in respect of his objection regarding Can 5 of 2021 and Can 6 of 2025, 5 of 2021 and Can 6 of 2025, I think it justified to give an opportunity to the respondent to demonstrate his matter. Accordingly, the application being Can 7 of 2025 is considered and allowed. Full stop. The order passed by this court on 14th of February 2025 in respect of Can 5 of 2021 and Can 6 of 2025 is hereby recalled. Let the both applications being Can 5 of 2021 and Can 6 of 2025 be listed for hearing.
Anything.
Pursuant to Lordship's earlier order, but I have deposited the special messenger cost. If my lord recalls the entire order, then my deposit of the special messenger cost got waived. Because my lord directed to deposit the special messenger cost to call for the LCR. Now, if the entire
LCR is required, LCR let it be there.
Let it be.
but that portion should
Okay,
be
okay, okay.
last portion. My lord,
কি বললাম বলো?
Yeah, sure.
Hereby no, না hereby recall করেছেন? Hereby recall subject to the portion of the order regarding except the portion of the order regarding recalling the trial court record and directions thereon. let both the applications being can 5 of 2021 and can 6 of 2024 be fixed for hearing on the next day. I don't have it. No determination. I don't have the determination now.
Are you asking him? Whether
Okay. Very good.
My lord may hear out today. Since my lord is having the determination, my lord will recall both are here. It's a simple restoration application, my lord, it not take more than 5 minutes.
No. Just let it be here. Okay.
And all, well, in that event, my lord, the order stands, the appeal stands dismissed. Order recalled, restoration
Section
recalled.
5 and 6 can 5 and 6 are there? Can 5 and 6 are there?
5 and 6 are there.
Original can 5 is not in the 5. Because I gave my copy to your lordship.
Okay, it is there. Now it is there. Yes.
May I take back my copy?
Yes. Honor copy.
And my copy also. It will be listed in the. Madam, can I fix a time at any point next week?
I do not know who will be the determination.
Unless there is because I am suffering an order of dismissal. Unless there is specific order being
My
passed,
lord, he is
then I-
suffering from 2019
So
for
what you
5
want now?
years.
What you want now?
My lord,
Let the date be fixed so that
My
on
lord-
case determination I
my
can
lord,
mention
for-
the matter before the court concern that it has been fixed by your lordship.
I do not know whether determination who will take up the
my
matter.
lord, my lord,
What will be the date?
for my learned friends acquaint knowledge, when I am saying one sentence. My lord, very recently, Supreme Court has said the section 5 should have a limit. How far the sword of Damocles will be there on the head of the winning party? How far? 5 years have passed.
Okay.
I knew that I have won the matter. It is the language used by the Supreme Court. All right, chalo.
12:30 matter.
I'm getting one.
Mr. Bakshi is leading me for appealing. অসুবিধা বুড়ো
Kindly, your lordship will peruse the order dated 28th February, last day of February, 28th February.
That's correct.
There's a direction for putting up notice. The direction, my lord, she has got it.
Yes.
Direction. And my lord, this notice and Talavana was put in on 18th March. Service return most probably has not come. And I find from the by calculation that there has been a delay of 3 days in putting. My submission will be accept that and direct service.
Delay of filing the appeal.
Yeah, I'm appellant.
There are 3 days delay.
Your lordship direct delay in putting in Talavana. There's according to my calculation.
You are for the appellant.
Fortnight from 28th February.
That's true.
It must be on.
Delay. I have no objection to that.
But then, Malay, it should be accepted and notice. তাই তো
না না আমি ওটা অবজেকশন করছি
তাহলে কিসের অবজেকশন না
কোনো অবজেকশন নেই মামলাটা হিয়ারিং করার জন্য
তাহলে এত ধরে আনা কি জন্য
মামলাটা হিয়ারিং করার জন্য
ও হিয়ারিং
পেপার রেডি
যবে হয় ফিক্স করো আফটার সার্ভিস ইজ কমপ্লিট
দিস ম্যাটার ইজ পেন্ডিং ফর
but without necessary party it cannot be heard.
That I can allow. Substitution application that
No,
allow.
no, notice.
Notice is there. That is part of the appellant.
Here we have put in.
Then okay.
Then
Notice of appeal upon all the respondents. Tolobana cost has been put in.
put in on my lord 18th March.
So you are appearing on behalf of all the respondents. So it is required to serve upon all the respondents. Have you received the notice?
Also respondents.
Now, whether both of you are complete respondent set?
Substitution respondent.
They have to be substitute.
The notice of the substitution has to be served.
That order was there.
Yes. They have put in the Tolobana cost.
And there is a direction for putting in Toloban. And rightly.
Cannot say that.
And we have complied with 3 days delay.
Very well, no issue.
Therefore, my lord, my prayer is, my lord, condone the 3 days delay and direct the office to serve notice.
So when you put in the Tolobana,
My lord, there is no report by the office.
report is not reached yet.
There is no report by the office.
No report.
দেখেন তো সার্ভিস রিপোর্ট আছে কিনা
Perhaps service report is not there.
Yes,
So
has been, my lord, no, office has noticed this.
no report.
Therefore, my lord, direction for service. Office.
No, in fact, this suit is a partisan suit. The thing, my lord, is if I am the interested party on behalf of the defendant, my response submission to that is the formal defect of the service having properly done on the upon the substituted respondent. Substituted respondent, they are probably they are not interested about it and their opinion they are not happy.
However, maybe they are to be served. Otherwise,
They
the
have to
appeal cannot.
file an application for dispensing with service.
আমি কেন করতে যাবো আপনি application
No,
submission
আমি
Very well. Please take down.
but loss is only things for you. This is the partisan suit started 61. Kindly appreciate with that. No, man, 60 that and thereafter 61 ta alag I respond submission to that. The date they fixed for hearing of the main appeal. The partisan suit.
Therefore, all
That's
parties
why I
are
fixed this matter at 12:30 on your submission. On your submission, I fix the matter. If the service of notice is complete, I can start the hearing today.
Again, I am submitting.
But the issue is that I don't have the determination now. From the 1st of April, I don't have the determination.
My response submission only to that aspect. Direction are given. I'll get to be fixing the date, any date. I can, my lord.
You have to mention before the
I
appropriate
can
date.
mention, but unless the department is completely proceeding.
Very well.
Therefore, I am praying
passing
for
down,
direction
I'm
of
passing down. Learned counsel appearing on behalf of the appellant submits
was
that
my prayer.
according in pursuant to the direction of this court on 28th of February 2025, this court, the appellant has put in the Tolobana cost with the department on 18th of March 2025. No report is reached regarding service of notice of appeal upon the substituted respondents. No report is reached to this court regarding service of notice of appeal upon the substituted respondent. Substituted respondent. The
3 days delay.
office is directed to serve the notice upon the substituted notice of appeal upon the substituted respondent, condoning the delay, if any.
3 days.
If any, condoning the delay, if any, and submit the report on the next date. Condoning the delay for submission of the putting up Tolobana cost.
Delay in complying with my lord's order.
Okay, কি বললাম আগেরটা বলুন আর লাইনটা বলুন। Serve the notice of appeal. Substituted respondent.
And DJ.
by condoning delay for if any for putting up the upon a cost by the appellant, comma, and submit the report on the adjourned next date. Full stop. Let the matter appear in the list before the appropriate bench in the second week of April. Submit the report. I have directed. Submit the report. Next.
Only I may be directed to sub the copy of the application for setting aside abatement with condonation of delay upon the opposite party. Because now it cannot be heard unless I sub the copy.
What is the application?
Application is CAN number 5 of 2024.
Okay, please take down. CAN 5 of 2024 is an application for substitution on account of death of respondent number 7. Full stop. The appellant is directed to serve the application upon the respondent and file an affidavit of service on the returnable date. Let the matter appear before the appropriate bench after service. Parties are liberty to mention. Next.
My lord, I am for the applicant.
Yes.
My application for restoration was pending because I had not put in paper books within time. So my lord was pleased to extend the time, my lord, for putting in the paper books till today. My lord, I have filed the paper books in the registry today against serial number 4, dated 28th of March 2025.
Mr. Banerjee, you are for the respondent. Give me a copy. Give me a copy. You have also received the copy. So
kindly restore, my lord, kindly recall the
application CAN 7.
CAN 7 has been disposed of earlier. CAN 6.
CAN 6.
And record be called for, my lord, at my special messenger course, so that, my lord, appeal can be made ready. I think Mr. Banerjee will not oppose to that.
Please take down CAN 6 of 2024. This is an application for restoration of appeal, which was dismissed for default by the order of this court on 27th of September 2024. The order of the Honorable Division Bench of this court on 27th of September 2024.
Order.
It appears that the Honorable Division Bench sitting in the Lojima jurisdiction has passed the order for dismissal on the ground that the appellant has not prepared the informal paper book, though there is a specific direction. First stop. The appellant is directed to file the paper book within this day. Full stop. Learned counsel for the appellant submits that he has submitted the informal paper book with the concerned department height.
Serial number 4, dated
Right,
28th of March 2025.
Serial number 4.
Yes.
Dated 28th of March
2025.
2025. Full stop. Mr. Banerjee, learned counsel appearing on behalf of the respondent frankly submits that he has received one copy of the said informal paper book. Considering the complaints made on behalf of the respondent number on behalf of the appellant, let the CAN 6 of 2024 be considered and allowed. Full stop. The order for dismissal passed by this court by the Honorable Division Bench under Lojima jurisdiction on 27th of September 2024 is hereby recalled. Full stop. The instant second appeal being SAT 3085 of 2006 is hereby restored to its original file and number. Full stop. Next para. The parties are ready. Let the TCR be called for. TCR, trial court record, be called for from the learned court below.
পুরোটা আসেনি একটা পার্ট বাকি আছে
Through a special messenger.
স্পেশাল মেসেঞ্জার
Special bear the cost.
Yes.
Through a special messenger, the cost to be owed by the respondent.
One prayer. The two parts of the TCR have already arrived. One part has not arrived. This is recorded in the order of 23rd September. So the remaining part or parts, if any, may be sent. First paragraph of that one. Two parts they are saying. So I don't know. I mean, maybe the lower appellate court records have come, but the trial court records have not come. I do not know. Or maybe
Files of TCR means both the files. One
according
in
to me,
lower
both the
court, one
files.
in
It should be
the
tagged with the file. তাহলে তো হয়ে যাবে।
So you check the file. Whether TCR
Lord, your lordship may be pleased to pass
If
an
any, if any.
order, if any.
If any.
Lower court records we call for,
if not already
called for.
Already received.
Already called
not
for.
already received.
কি বললাম বলুন? Let the TCR be called for from the office of the learned trial court. If not, through a special messenger, cost to be borne by the respondent. If not already received. Okay. So let the matter go out of the list.
Yes.
Party is liberty to approach the appropriate bench for fixing the matter for hearing.
The order of dismissal was 23rd as amended by order dated 27th. It has perhaps gone down as 27th. The order of dismissal was 23rd.
23rd of
September 2024 as amended by order dated 27th September 2024.
Can 6 তারপরে
Practically not amended, my lord. 27/9/2024 is not an amended order. Only a stand dismissed.
Stand dismissed.
Yes.
when it was dismissed.
It was dismissed on 23rd.
23rd,
See these two orders.
23rd 9/2024.
Yes, it was dismissed.
That
on
is the order.
So 27th is what?
27th, there's another order where the Honorable Bench says the order dated 23rd September is mentioned for correction. In the last sentence of paragraph 4 of the order dated 23rd September 2024, the expression particularly can 5 of 2023 are dismissed shall stand deleted and be replaced with the expression shall stand disposed of.
Okay.
So 23rd, not as amended by.
ওইটাই তো হয়েছে না। কারেক্টেড হয়েছে। এইটাকেই তোমার
এটাই প্যারেন্ট অর্ডার হয়ে গেল।
amended by order dated 27/9/2024. দুটোই রিকল হয়ে amendedটা রিকল হবে তার
না, ওটা তো পার্ট অফ দিস অর্ডারই হয়ে গেল। এটাই হবে
হ্যাঁ
ড্যামেজটা হলে এই অর্ডারটা ফুল হলো তারপরে রিকল।
এটা কমপ্লিট হলো না যতক্ষণ না এই
এটা অ্যামেন্ডটা আসছে, সুতরাং এইটা অ্যাজ অ্যামেন্ড।
তাই তো
By this court by the Honorable Division Bench on 23rd September 2024
as corrected
as
by
amended on
as
27 September
September
2020 action করতে পারে 24 হ্যাঁ বলুন তারপর কি হলো September 2024 is here very good. Okay, okay, okay. Take it.
Lord, I believe you.
Yes.
Lord, my apologies, Lord, from the
No,
side
no,
of the
that is not the issue.
parties.
We are dealing with these matters for various years.
I could not restrain myself, my Lord. My apologies.
No,
again.
no.
But there is certain
You should not be. You should not be take them.
Hey, he is appearing for his client.
এইটা
No,
ঠিক
এটা
বলছি না,
নয়,
আগে-
এটা-
আগে একটা matter।
No,
Oh,
no,
again
that is
he
not
has
the
said,
issue.
all of us, Lord,
I know there are some persons like that in every bar.
Lord, all of us, Lord,
This kind of
really
language is
very-
impermissible. I could
very
not
sorry.
hold myself back.
Yes.
Very okay.
In this
issue.
institution, my Lord, we should not. Our bad name will be there. If one person does like this. Decorum of the court is to be maintained. And your lordship respect is our respect.
Yes, that is why my Lord is the High Court. My Lord's respect is our respect.
Our respect.
That is why, my Lord, I could not restrain myself.
Somehow someone could
We
not
have to
understand
maintain
this.
your lordship.
Next matter. Yes.
My lord, in item number 20, I am appearing for the respondents. My lord, this appeal, second appeal has been preferred by the, my lord, defendant tenant challenging an order and, my lord, a decree of eviction passed by the first appellate court. Now, my lord will see from the order sheet, my lord, an order was passed on the 13th of July 2007, formulating the questions of law, my lord, and staying the order of execution. Execution proceedings had been filed for eviction, my lord. Now, there was an order of stay passed. Now, my lord knows that once the landlord-tenant relationship has been severed by the decree of eviction, my lord, the tenant ought to pay occupational charges. My lord, for that purpose, my lord, I have taken out, my lord, can number 2 of 2008, my lord, which with the old number being 4045 of 2008, my lord. My lord, my humble submission in this application is that the stay has been, my lord, stay has been granted in respect of the execution proceeding for the last, my lord, 17 years. My lord, in the last 17 years, the defendant tenant has not paid any occupational charges, my lord. They are enjoying the property free of cost. My lord is aware of the decision rendered by the Honorable Supreme Court in the Atmaram case that once the tenant and landlord relationship is severed, the tenant is bound to pay occupational charges at the current market rate, my lord, so as to compensate the landlord for keeping him out of possession of the property since the execution of the eviction decree stands stayed.
So you are the respondent.
My lord, I am the respondent. Unfortunately,
You are for the appellant. You are for the appellant. So what is the application? Application being?
my lord, application is can 2 of 2000 and can 2 of 2008, my lord. The old can number being
4045.
yes, my lord. That is
Yes.
the old can number. Yes.
Old application is
Have you filed
4045.
any affidavit?
I have already filed an affidavit in opposition in this regard.
My lord. May I proceed with my application if my lord so permits?
When you file the affidavit?
Affidavit has been filed.
My lord, the affidavit was affirmed on 21st of November 2011. And it was, my lord, affirmed by, my lord, Sushanto Jal.
Sushanto Shah.
Sushanto Shah, sorry.
It can. Affidavit. Affidavit then.
Has my lord signed the affidavit? The affidavit in opposition was affirmed by one Suraj Tiwari, my lord. Suraj Tiwari, on behalf of the plaintiff defendant appellant.
First September.
Suraj Tiwari.
21st November 2000.
See the back side. পেছনটা দেখুন।
Affidavit of opposition. Your Worship, may I hand over my office copy?
Give me the papers, give me the papers. ফাইল বের করতে পারেন না, কোথায় গেল ক্যানটা? Give me the objections. এই অবজেকশনটা কোথায় গেল? চেক করছেন বিশ্বনাথ, অবস্থা খারাপ করে দিচ্ছে ফুটেজ। Yes.
Yes.
You can
May I-
proceed.
Yes, my lord. If my lord kindly takes up my application at page 2, my lord, I have made out the case. Kindly sees from paragraph 2 onwards at page 2. My lord, on or about 13 July, this honorable court was pleased to admit the above appeal preferred by the appellant above named from the judgment and decree dated December 21, 2006, passed by the learned judge, 6th bench, City Civil Court at Calcutta, and directed stay of execution of the said decree. So, my lord, the first appellate court, my lord, had decreed the suit, my lord, and had granted.
Do you have the Atmaram?
No, I'm for the respondent.
Do you have the Atmaram?
No, Atmaram judgment नहीं है मेरे पास.
He's not.
Eviction bench judgment I am holding.
To submit the Atmaram.
No, my lord, I may be apologetic. Excuse.
My lord, I may give the citation, my lord. Will it be of any convenience if I give the citation, my lord? It is 2001-5, volume 1, SCC, page 705.
2005.
2005, volume 1, Supreme Court cases, page 705. And my lord, the conclusions are given in paragraph number 19 and 20, my lord. Paragraph numbers 19 and 20. If my lord so permits, may I read from that judgment, my lord? May I just indicate the case before my lord goes to the judgment?
Yes.
My lord, kindly see my application, paragraph number 4, my lord.
Yes.
At page 3, it is the admitted case of the appellant that he was a tenant under your petitioner in respect of a portion of premises number 48 by 1B Ramkanto Bose Street. My lord, will kindly come to paragraph number 7. By a judgment and decree dated December 21, 2006, the learned City Civil Court at Calcutta allowed the appeal. The appellant has preferred the above second appeal from the said judgment and decree. In the above appeal, the appellant has also filed an application for interlocutory orders. Now, my lord, will kindly see paragraph 9 in the next page, my lord. By the said order dated 13 July 2007, which order was passed by this honorable court, my lord, this honorable court was pleased to admit the said appeal and to direct that the execution of the said decree dated December 21, 2006 be stayed. However, it appears that the appellant intends to enjoy the suit premises without making any payment at any sum whatsoever, which is impermissible. The appellant has not made any payment from May 2006. The market rent for the said premises is rupees 1,200 only per month. Your petitioner has been advised that your petitioner has a good case, and this honorable court would be pleased to dismiss the above appeal on hearing. In the circumstances, it is respectfully submitted that this honorable court would be pleased to direct the appellant to forthwith pay all arrears of rent along with interest at the rate of such and such, and pay the sum of 1,200 only as occupation charges from December 21, 2006 till disposal of the appeal. My lord, will kindly takes my prayer, my lord. My lord, my first prayer, my lord, that directed to forthwith pay all arrears of rent along with interest at the rate of 8.33% per annum and to pay the sum of rupees 1,200 only as occupational charges from December 21, 2006 till disposal of the above appeal. Now, my lord, I have made this application because today, I being a landlord, I am enjoying a decree of eviction, but I am unable to put the decree into execution because of the stay granted by my lord under order 41 rule 5 of the Code of Civil Procedure. Now, kindly takes up their opposition, my lord. My lord has been handed over with a copy of their opposition. Kindly sees what is their objection to this. If my lord takes, my lord, page 6 of their opposition at paragraph 8, my lord, this is the pivotal paragraph on the basis of which his objection is sought to be made by the appellant. With reference to the statements made in paragraph 10 of the said application, I state that the respondent had made the statement without having any basis. In this context, I state.
Paragraph?
My lord, paragraph 8 at page 6 of the opposition.
Paragraph 8.
Yes, my lord. With reference to the statements made in paragraph number 10 of the said application, I state that the respondent has made this statement without having any basis. In this context, I state that I have been all along depositing the occupational charges equivalent to the monthly rent at the rate of rupees 80 only per month, payable according to the English calendar since the month of March 2006 and onwards up to the month of May 2011 in the court of the learned judge, second bench, the Presidency Small Causes Court at Calcutta in connection with the aforesaid ejectment suit number 21 of 2003. And as such, I deny and dispute the statements made by the respondent to the effect that I have not made any payment from the month of May 2006 alleged. I also deny that the present rent of the suit premises is 1200 only as claimed by the respondent, and such I put the respondent to the strictest proof thereof. Photocopies of the relevant challans showing depositing the occupational charges equivalent to the monthly rent from the month of March 2006 up to the month of May 2011 are here to and collectively marked with the letter A. So, my lord, twofold defense that they have taken in their affidavit in opposition. The first one is that they have deposited the rent before the learned trial court till 2011. There is no explanation. There is nothing stated as to what happened after 2011. Second of all, my lord, they have simpliciter denied that the occupational charges or the present rent of the suit premises is rupees 12,000 per month. This simple denial, there is nothing else. Now, my lord will see that this second appeal, my lord, was registered in the year 2007. Second appeal number 487 of 2007. For the last 18 years, my lord, they have not moved this second appeal and they have been continuing to enjoy this order of, my lord, a stay of the execution. I am only humbly submitting. I know my lord does not have the copy of the judgment of Atmaram. May I just read paragraph numbers 19 and 20? My lord already knows. I need not read it also. My lord knows once landlord-tenant relationship is, my lord, severed by a decree of eviction, they are liable to pay occupational charges. May I just read paragraph number 19?
Yes, read up.
Yes, my lord. To sum up, our conclusions are, while passing an order of stay under Rule 5 of Order 41 of the Code of Civil Procedure 1908, the appellate court does have jurisdiction to put the applicant on such reasonable terms as would, in its opinion, reasonably compensate the decree holder for loss occasioned by delay in execution of decree by grant of stay order. In event of the appeal being dismissed and insofar as the proceedings are concerned, such terms, needless to say, shall be reasonable. In case of premises governed by the provisions of the Delhi Rent Control Act, my lord, this was rendered in respect of, my lord, Delhi Rent Control Act, but my lord knows that Delhi Rent Control Act and West Bengal Premises Tenancy Act more or less are identical. The definition of tenant is also, my lord, the same. Section 2G of the West Bengal Premises Tenancy Act defines tenant as a person who continues to be in possession, however, unless a decree of eviction is passed, my lord. Here in this case, my lord, decree of eviction has already been passed, so he has stopped being a tenant. Unless, of course, the second appeal is allowed. But as on date, as we stand before my lord today, he is no longer a tenant. Now, subpara 2 of paragraph 19 of the judgment, in case of premises governed by the provisions of Delhi Rent Control Act 1958, in view of the definition of tenant contained in clause L of section 2 of the act, the tenancy does not stand terminated merely by its termination under the general law. It terminates with the passing of the decree for eviction. With effect from that date, the tenant is liable to pay mean profits or compensation for use and occupation of the premises at the same rate at which the landlord would have been able to let out the premises and earn rent in the tenant if the tenant would have vacated the premises. The landlord is not bound by the contractual rate of rent effecting for the period preceding the date of the decree. The doctrine of merger does not have the effect of postponing the date of termination of tenancy merely because the decree of eviction stands merged in the decree passed by the superior forum as a later date. In the case at hand, it has to be borne in mind that the tenant has been paying rupees 371.90 rent of the premises since 1944. My lord, in our case, the rent was rupees 80 per month. The value of the real estate and rent rates have skyrocketed since that date. The premises are situated in the prime commercial locality in the heart of Delhi, the capital city. It has been pointed out to the High Court that the adjoining premises belonging to the same landlord, admitted 2,000 square feet, have been recently let out on rent at the rate of rupees 3,50,000 per month. My lord, thereafter, my lord, the Honorable Supreme Court goes on to say, we may place on record that it has not been the case of the respondent tenant before us, nor was it in the High Court. The amount of rupees 15,000 assessed by the Rent Control Tribunal was unreasonable or grossly on the higher side. So, my lord, ultimately, my lord, an amount of, my lord, rupees 15,000 was granted to be paid by the tenant on account of occupational charges. My situation today, my lord, is extremely precarious because I am a landlord. I have a decree of eviction in my favor, but for the last 17 years, I have been unable to execute because of the stay granted by this honorable court. Now, this honorable court may very well grant the order of stay if my lord thinks that the second appeal is required to be heard. But the appellant must be put on terms, my lord, for payment of occupational charges. So, my lord, I'm humbly submitting, my lord, I have asked for an amount of rupees 1,200 per month. My lord will see that this application was made in the year 2008. As we stand in 2025, my lord, the rent has skyrocketed since then. I would humbly submit, my lord, to direct the appellant to pay reasonable charges as rent, whatever this honorable court thinks, from the date of grant of stay, my lord, till date, put in the arrears immediately, failing which, my lord, I would request, my lord, to vacate the order of stay and allow me to proceed with the execution. These are my most humble submission.
So what is your justification regarding the amount? 1,000?
My lord, yes. My lord, initially, my lord will see that this amount that I have mentioned in my application, my lord, I'll just indicate, it was, my lord, rupees 80. Now, this rupees 80, my lord, the landlord, my lord, will kindly also see that the decree of eviction, which was passed, my lord, I'll just indicate that. My lord, the suit was filed in the year, my lord, 2002, my lord, subject to correction. And my lord, at that point of time, I had filed a suit for eviction, my lord. That point of time, the rent was rupees 80. If my lord simply takes the escalating rate of rent in the last 25 years, my lord, more than 25 years have passed, the rent has escalated substantially, my lord. My lord, the area that is being occupied by, my lord, the tenant at my lord, the tenanted premises as 48 by 1B Ramkantopo Street, my lord, is a substantial, and I believe it is being operated as, my lord, a shop room.
What is the area of the shop room?
My lord, I'll just indicate. Kindly grant me one moment.
There is no materials regarding the rate of rent like that prevailing in the area.
My lord has sufficient discretion, my lord, to even look at the quantum of rent which was initially paid and thereafter escalated. Maybe there may not be any materials on record right now. We are not here to give evidence before my lord in the second appeal stage. But my lord, this is what the appellant should have done when they were praying for stay, my lord. They should have indicated what was the rent, what was the area, so that they could pay the required occupational charges. But they completely suppressed it before this honorable court and obtained an order of stay, my lord. At that point of time, we were not represented. It is also a fault on our part. But my lord, this was also the obligation of the, my lord may direct the parties to indicate the particulars of the tenanted property, my lord, so far as area is concerned, or my lord may permit us, the parties, to file a supplementary affidavit to indicate what would be a justifiable market value of rent at the present stage, my lord. And my lord has to grant an order, my lord, for occupational charges from 2008 till 2025. It cannot be the same quantum. It has to be, my lord, periodically, because my lord knows, even as per the, my lord, Rent Act, the rents are enhanced every 3 years by, my lord, 10% or so. So my lord may grant us liberty to file supplementary affidavit to indicate what would be the appropriate market letting out value from the period from 2008 to 2025. This is, of course, subject to the discretion of my lord. Whatever my lord.
May I please, Your Lordship? Your Lordship, I have indicated in my affidavit in opposition that from the date of decree from the title appeal from the City Civil Court, I am regularly paying rupees 80, which was the quantum of the rent, regularly paying in the trial court below. Till date, I am still depositing the said rent, which was the amount fixed by the court at the time of deciding 17-1, 17-2 with the trial court. Very cleverly, the learned advocate of the respondent skipped two paragraphs of their applications. Paragraph 5 of CAN 4045 and 6. The suit was dismissed in the suit, in the trial court, on the ground of non-service of the eviction notice, and the defaulter ground was not proved, as because 17-1, 17-2 default of rent was set aside. On that ground, that the suit was dismissed. They preferred an appeal before the learned Chief Judge, City Civil Court. Chief Judge, City Civil Court. Later on, it was transferred. In that appeal, they have never urged for any occupational charges. We regularly paid rupees 80 as described in the eviction notice also. We regularly paid the rent.
There was no eviction order.
There was no eviction order. I regularly paid. After that, the appeal was allowed, and we preferred this second appeal. The second appeal get stayed without any occupational order. We went on going paying the said amount. Till date, we are still paying the said amount. Till date, we are having the challan copies with us. If your lordship grant me permission to file a supplementary affidavit.
Very well. I allow both of you to file the supplementary affidavit.
Yes, sir.
Please take down.
My lord, may I be permitted to place? My lord, area is North Calcutta and property is adjacent.
File supplementary.
Yes.
You file
My lord,
supplementary.
so far as I know, the division bench judgment of Calcutta High Court, the appeal is infructuous. Subsequently, all CAN applications should be dismissed. My lord, there is a judgment passed by Honorable Justice Bhaskar Bhattacharjee and Prabhat Kumar De, a similarly case mine. My lord, kindly see the judgment. Appeal is infructuous. Appeal itself should be dismissed. And all connected applications should be dismissed. Infructuous appeal. Original tenant has died. Thereafter, his wife has already been died. Thereafter, his son is staying since more than 5 years. 5 years has already been passed. So many 5 years has already been passed. My lord, they have no right to continue the appeal. Appeal is infructuous.
He has to file a separate.
My lord, kindly judgment 2010 volume 3.
So the appellant expired.
Yes. Original appellant expired. Let me say,
substituted.
Original tenant Barman Tiwari has died. Thereafter, his wife has already been died, and his son is staying so many 5 years without paying a single naya paise to the landlady. But our appeal is infructuous. We do not want to any single naya paise we do not claim. My lord, he should be, I may be permitted to proceed with the execution case. Appeal is infructuous, my lord, kindly. Judgment 2010 volume 3 CHN Cal 443 passed by Honorable Justice Bhaskar Bhattacharjee and Prabhat Kumar De.
Your lordship, from the orders 2nd March to 2021, the appellant has been substituted.
Whoever he may be, my lord, original, this judgment is.
Now, whether it was substituted?
Yes, sir.
All layers have been substituted.
There was CAN 2710.
My lord Justice Honorable Sivakant Prasad.
4472.
Appellant has already been died, and landlady respondent has already been died.
Don't mislead. Kindly help the court. CAN 4472 of 2013.
4472 of 2013.
13. The order dated 2nd March 2021, and CAN 4794 of 2015. Both the appellant and
What I have wrong?
respondent names were substituted.
Maybe
Even
this
the-
order is with
Even
me,
the
my lord.
respondent died.
Yes, substitution was made.
Substitution was made, and from the order dated 2nd March 2021,
4794.
4794 of 25,
Yes.
2015.
Well, this is the order passed by
No,
Honorable
what-
Justice
what you-
Shivakant Prasad.
What you want to submit, there is no substitution.
Yes, substitution has been made.
Then what you want?
My lord, I want the appeal should be dismissed. The appeal does not lie. As the original tenant has already been died.
Your Lordship, my humble prayer is dispose of this second appeal as soon as possible, dismissing these applications and delaying this appeal. Let it hear the second appeal.
Appeal is infructuous, my lord. Kindly, I am filing the judgment passed by Honorable Justice
In
Bhaskar
the
Bhattacharya
first
and
appellate
Prabhat
court,
Kumar De.
the respondent never asked for any occupational charges. My humble prayer, proceed with the second appeal.
For the respondent.
Yes. I am an advocate on record.
Very. Learned advocate on record appearing on behalf of the respondent submits that the appeal has submits by citing a judgment of this court, reported in Monty De versus Chandralekha Roy, reported in 2010 within bracket 3 CHN Cal within bracket Cal 443, that the appeal has already been
Infructuous.
Infructuous.
appeal has already been infructuous due to the death of the original tenant. Full stop. Learned counsel. Full stop. Can 4045 of 2008 is taken up for hearing. During course of the hearing, it appears that the application being Can 4045 of 2008 cannot be disposed of without giving the appropriate opportunity to the parties, to file the supplementary affidavit, if any. Let the supplementary affidavit be filed within the urgent date. Full stop. The prayer for disposal of the appeal being infructuous would be considered on the next date. Full stop. The learned counsel for the appellant is liberty to contradict the submissions as made by the learned counsel for the respondent on respondent on record regarding the pendency of the instant appeal on the next day. Let the matter appear in the list on the second week of April.
Your Lordship,
Before
I'm
the
having
appropriate bench.
personal difficulty from 12th to 22nd of April.
Second week will be within 11th of April.
If it, Your Lordship, if not 11th, then 12th onwards, I will not be here.
12th is a Saturday. So what you want?
Prior to
11th of April is fine, my lord. We'll come back by 11th of April. It's a Friday, my lord.
Not the 11th. I don't have the determination now in the second appeal. You approach the appropriate bench. Okay.
Very well, my lord.
The second week. Yes.
Before
No.
Before
Will it
my
be my
lord,
lord's pleasure to direct the second appeal to be placed before the bench having determination?
Having determination.
Yes, my lord.
Appear before the appropriate bench. Having
I'm
determination.
extremely grateful to my lord.
before my lord rises, my lord,
before
I
rise-
come with a very innocuous prayer, my lord. As my lord,
1321.
today is Friday, lordship, and second up, lordship will take up the original side matters. Lordship, I am similar matters are pending regarding the vacancy, lordship. Now, lordship, I ask leave to file this application, lordship, which is affirmed. Unless leave may be obtained, Lordship, it will not be filed, and GP office.
Why are you mentioning to now?
Lordship, GP office will not accept the service by today
You have
itself.
to, first up, you have to mention the matter.
Lordship, that is my inability to
can I
come before your
every day-
Lordship, but Lordship,
Every day, all
no,
time.
not every day, Lordship.
mentioning.
I am seeking this liberty, Lordship, before your Lordship.
No, no.
Leave may
that
be
now
granted,
cannot be
Lordship.
done like
I,
that.
I will serve the GP office, Lordship, and come back on Wednesday,
You
Lordship,
have to
because
come on first up.
Lordship, that is my inability. So I
Now,
failed to come on
out
first
of
up, Lordship.
crucial hour of this court.
But Lordship, I was.
Now come on Monday.
But Monday is the holiday, Lordship, and
Then Tuesday.
and
I will-
your Lordship has heard this matter on Wednesday, Lordship, Friday and on Tuesday and Wednesday.
Come on,
So Lordship,
come on Tuesday.
Lordship,
I will
if
take
I
up
op-
the mentioning on Wednesday, though your matter will take up. No issue.
Lordship, unless GP office will not accept the service, Lordship, that is the difficulty. Other 48
That's
services.
why you mention on
Lordship,
Monday, Tuesday first.
Lordship,
First
I
up.
am just asking for a leave to obtain the regular number, and the
No,
GP
that is not the procedure. You know, I cannot allow you. I have to allow all the persons.
No, Lordship.
Yes.
Item
number 26, my very innocuous prayer, my other side is here. May I file the paper book? I have already served them. Kindly.
This is the application.
The application, my lord, because there was a specific direction for preparation of paper book upon us also, my lord, earlier order. We have prepared, my lord. Let the paper book be filed. We have kept it the record, my lord. I have served them with a copy of the paper book.
Item number 26.
26, my
You
lord.
file in the department.
Department, my lord, difficulty is, my lord, if we file the department, then the eviction suit, again, department will call for the paper book. That's why if we kept with the record. That's, I'm a humble prayer.
I have not reached there. Otherwise, the order has been passed.
The other side is also here, my lord.
If you file the paper with it, they will lost. Today I five record, I cannot find my orders.
If there is a specific order, it will be with the record itself. Because the workout record is also here, my lord. That's the.
So you file with the department. What is the difficulty? You
As
have
you-
a copy file with the department.
As you
No issue.
Lord, only. Lord,
No, today how can I?
Proceed.
Lordship, may I have the liberty to mention? I know this is not the time to mention, but Lordship, this is urgent. If your Lordship recalls, Lordship has heard this matter extensively. PL Malik versus Khaitan Consultant Limited, occupational charges. But as the new determination has come, we are requesting just to mark it as part heard.
Can it be done today because it's not having in the list? Monday it can be taken as fully mentioned, but Monday your Lordship will not be having.
There is celebration of
Tuesday.
Tuesday one. There are two matters.
Can appear as fully mentioned, but whether your Lordship will take up as fully mentioned on that. I had a talk with
How can I take up the matter to mention it is?
Lordship can mark it as part heard.
I had a talk with my senior also, my lord. He said
Because Lordship
but only
has
how to do it.
Yes.
Lordship has heard this matter extensively. Arguments are complete. Just 10-15 minutes are left. If
No,
your
argument
Lordship
has not completed. Argument has not completed.
application,
not
Lordship,
the
we are just telling for application. Just for application.
You try your luck before the appropriate bench.
Lordship,
It
it has been done extensively. On 4 occasions, it has been heard.
I understand. I understand.
There is
But
urgency.
how can it be done?
Lordship,
the
just
situation-
one matter. If your Lordship can just see last 2 orders.
I know that, but
Lordship, we are requesting Lordship.
if
Cost
both
efficient
parties are
also
there,
goes.
then I can understand.
Yes,
How
Lordship, both parties are here.
They have given us notice.
We are mentioning upon notice.
Submitting it, sir, I don't know how to do it because today it is not a listed matter. So it cannot be done today.
Lordship, a supplementary list can come out if that is the case.
No, supplementary list today, it cannot be possible. Otherwise, it would be said that I have the interest to do the matter. That
Lordship
is-
then can mark it is fixed. What it is fixed on 9th.
So
9th
fix
at
the
3
matter,
PM.
both parties are ready. You can try your luck before the appropriate bench.
Lordship,
This is the determination changed by the Honorable the Chief Justice. So what?
Lordship, that determination is effective from 1st April. So today, if your Lordship can
You
do-
know, different matters are pending matters.
I
have
get
to
it.
lost every matters. I
I
consume many.
I
times.
agree, Lordship, but
I suppose to dispose of this matter within the 15 days like that. And some continuous matter, other matters
Lordship,
also
just
there.
not the entire second appeal, just this application.
No, that cannot be. Apart from the second appeal, how can I take up that?
Lordship, okay, the second appeal entirely, because this matter has been extensively heard.
No. Second appeal has not been heard or puttered like that.
The
I cannot
application
put the
has
matter for the application only. You know the difficulty.
Lordship, the application has been
This is
heard
the regular
extensively.
in the High Court. When determination change everything, we also consume some time. Learned advocates also again argue on the matter. When I take up the second appeal determination, there are 4 to 5 matters which are puttered and argument has been concluded. Then again they have to appear before this court. And this
Lordship,
is a
just
matter of
one
application.
matter, this was heard extensively
I know.
on 4-5 occasions. There are 2 matters of this
I
one,
know,
just one.
I know, madam, but how can it be done? I have also extensively determined the matter. I intend to dispose of the matter, but how can we? Very well, thank you.
Much obliged.
Much obliged.
Much obliged.
I appeared for the petition. This is a correction of the order.
Please take down. This matter appears for correction. In the last paragraph of order dated 21st March 2025, the adjourned date was erroneously mentioned as 4th July 2025. It should be read as 4th of April 2025.
My lord, instead of 4th April, my lord, kindly, if my lord keeps
Again
some-
4th April.
Lordship,
Only 4th April will be there.
Lordship,
Correction means correction,
Lordship,
not
Lord-
further.
Lordship.
Only July will be April.
Grateful one.
Only correction হয়ে যাবে আর কি আর কিছু কথা আর কোনো যা আছে তাই থাকবে only ওইটুকু correction আর কিছু হবে Next.
We are for the petitioners.
On the last occasion, my lord, I have shown.
Yes, you have argued extensively in this matter.
Yes.
Regarding everything you have disclosed, but you have not cited any judgment law like
As
that.
of now, I have not cited any judgment. My lord, I
Some
have.
portion of the fact was also remaining.
Yes, yes, yes.
Yes.
Now, so far as the inspection reports, those are I have already shown, my lord. The endorsement on the inspection reports, the endorsement of the distributor concern on the each and every inspection report with regard to their objections at all, if any. And I have also shown the marketing discipline guideline, which has been relied by the writ petitioner with regard to the provision of usage of the platform-based weighing machine. It was the writ petitioner's case that it is the duty of the inspection team of the internal corporation to weigh it on the weighing machine, referring to a particular clause of the marketing and discipline guideline, particularly clause number.
Your submission was that the distributor has to provide the weighing machine.
First of all is that responsibility, whether that responsibility is with the internal corporation to weigh it on a weighing machine, or it is the responsibility of the petitioner, because the particular clause 1.4c, which was referred, 1.4c of the marketing discipline guideline, which has been referred by the petitioner with regard to this context, saying that it is the responsibility of the corporation to weigh it on a platform-based weighing machine. In referring to that clause in my submission, what I have stated, that clause, as per that particular clause,
That
it
has
is
to
the
be complied with by the petition.
So that is one aspect. The second aspect is the why it was not done on the platform-based weighing machine, and instead of that, it was done on hand weighing machine. Even in that respect also, I have submitted that the weighing machines, either it is platform-based or hand weighing machines, those are being provided by the distributor to the inspecting team.
Yes.
In this case, it was the distributor who has provided the hand weighing machine. Number one. Second, it was our categorical stand that the inspection happened en route. So in case an inspection happens en route, then it is the delivery man who has to provide the weighing machine, and in all probability, the delivery man has to carry a hand weighing machine, because it is for the purpose of the satisfaction of the customer. When a delivery boy delivers the cylinder to a customer, if the customer asks the delivery man to weigh the cylinder, then he has to provide. For that purpose, the delivery man has to carry a hand weighing machine. So since the inspection happened en route, according to delivery boy of the petitioner provided a hand weighing machine. So these are three aspects. Why a platform-based weighing machine was not used, and instead of that, an hand weighing machine was used. Both are electronic. Because both are electronic. It's not a case that the platform-based weighing machine is not an electronic, is an electronic one, and the hand weighing machine is not an electronic.
At least 2 digits after the.
Yes, both
decimal.
are right. Both are electronic. Now, so far as the compliance of the particular rules, the meteorologic rules, that
legal metrology, packaged commodity rules 2011.
Yes.
The writ petitioner case was that there is a violation of that.
Yes.
Referring to
One point four C.
No, my lord, 1.4C is the marketing and discipline guideline, which is at page 70, page 49 of the writ petition.
Yes.
That I have shown already, because that is for the purpose of, that is the marketing discipline guideline of the corporation. Petitioner case was that corporation has violated this condition. So there should be a mandamus. My case is that this clause is not at all for the corporation to comply. It is the petitioner who has to comply. Now, the other clause, the other provision which has been relied upon is the provisions of legal metrology packet commodity rules 2011.
Where is it?
It has, I think, my lord, it has been handed over. It is not annexed with the writ petition, but it has been handed over to your losses. If your losses sees the grounds in the writ petition, they have specifically relied on the provisions.
Meteorological rules একটা আলাদা করে দিয়েছিল।
দিয়েছিল না?
দেয়নি কিছু? আচ্ছা, আচ্ছা, আচ্ছা।
My learned friend has referred Rule 21. Yes. In ground number 8 of the writ petition, they have relied on rule number 21. May I place the specifically the ground which has been taken in the writ petition at page 17, ground number 8. For that, under rule 21 of the legal metrology packed commodity rules 2011, if an inspection of quantity or error in packages of the premises of the dealership is carried out, and that, may I pause here for a moment? It says packages of the premises of the dealership. My categorical stand was it was en route, not at the godown,
Premises.
not at the premises. So far as the inspection of premises is concerned, it was also carried out. So far as this particular charge of irregularity was not found at the premises, because I have placed all the inspection reports. The inspection,
There are some inspection report in respect of the premises, go down, everything.
Yes.
Office room are there.
Yes, yes.
So your submission is that the discrepancies appearing in the
in the
question,
end route, in the
en route,
not at the,
not within the premises of the.
Right. So this particular clause, if at all, assuming without admitting it, is not been complied with, in my humble submission, this is not at all applicable so far as the particular discrepancy is concerned. Now, may I place the ground again, my lord? And that an error in deficiency in any package kept or stored for sale, distribution, or delivery at the premises of the dealer is found to be more than the maximum permissible error in relation to that commodity, then such package could be seized, but no punitive action shall be taken against the dealership if the authorities are satisfied that the package bears the legend when packed and that the deficiency in the net quantity is due to environmental conditions, and further, if the said package is found to bear all or any other declarations required to be made under the legal metrology rules. Inquiries are required to be made at the source from which such package was received by the dealer. Yes. I have shown, my lord, the relevant clause of the marketing discipline guideline, which says while unloading the cylinders, it is the responsibility of the distributor to first of all carry out a random
checking,
so
random
far as,
verifications.
random checking so far as the payment is concerned. Thereafter, before any cylinder is loaded in the on the delivery van for distribution, it has again each and every particular cylinder has to be weighed on the platform based weighing machine by the distributor. And at that point of time, if the distributor finds that any cylinder is underweight, then it has to keep it at a separate place for returning the same cylinder to the corporation. So this action has to be taken by the distributor to avoid anything in the during the inspection en route. In my humble submission, this particular provision of the rule is not applicable, is not attracted in the given facts and circumstances of the case. The Indian Corporation, as per their marketing and discipline guideline, it cannot take any steps of an underweight weighing cylinder if it is found underweight being delivered by a oil corporation. It has to be returned back. In compliance of this provision, in other words, what I may also say, in compliance of this provision, marketing discipline guideline stipulates a condition that stipulates a provision for returning the underweight cylinders to the bottling plant only to comply with these particular rules, because Indian cannot take any punitive action as per this rule. So the compliance has already been made in so far as this particular rule is concerned on the part of Indian Oil Corporation in formulating the guideline itself. Because I have shown that particular clause of the marketing discipline guideline clause 1.2 at page 48. To comply with rule 21, this has been framed. Clause 1.2 at page 48 of the guideline. Separate area should be marked in the LPG storage godown for keeping filled, empty and defective cylinders for each type of cylinders, so that the distributor may not face any punitive action. In the given, so far as the discrepancy is concerned, my first submission is so far as the discrepancy is concerned, this particular rule 21 of the rules is not attracted. Second, so far as the allegation that Indian Oil Corporation has not complied with this rule 21, in my humble submission, Indian Oil Corporation has complied. So in formulating the guideline itself, guidelines provides for provisions so that this clause can be complied with.
Yes.
Now, the other point which was argued, saying that the recording of the women in the inspection report does not contain 3 digit after decimal, which is a requirement under the rules, metrology rules. The requirement is the weighing machine should reflect, the electronic weighing machine should reflect 3 digit after decimal. But the inspection report says that the weighing machine which recorded the weighing of the offending cylinders does not record 3 digit after the decimal. Now, if you lodges kindly appreciate, my first point was this was not the weighing. If there is a defect in the weighing machine for not reflecting 3 digit after the decimal, then the responsibility is on the distributor, because it is the distributor who has provided the weighing machine. My second submission on that context is, suppose, my lord, if just kindly sees the may I place that inspection, one of the inspection report once at page 80. My lord, the cylinder numbers are given.
Page 80.
80 of the writ petition. Cylinder numbers are given. Thereafter, the next column is tear weight. Now the next one is gross weight.
Yes.
So after that, if we see the variation, like what, then the variation is given, the next column -10. Now kindly appreciate, if there are, if assuming, well, the highest digit after a decimal can be 9 and the lowest digit after a decimal can be 0. Now, assuming that the weighing machine actually showed 0, then these records are fine. The first digit recording is there. The other 2 digit, the recording of the other 2 digit of the after decimal, if were 0, then there will be no difference in the variation. In case the other 2 digit after the decimal are on the higher side, then there can be variation. There can be the difference in the variation recording. In my humble submission, my lord, this factual aspect cannot be adjudicated without leading evidence in a writ procedure.
You have also submitted that this point of
en route, whether
this point regarding the weighing machine is weighing machine and recording thereof is only 1 digit after decimal is not correct by the officers, was not raised before the appellate forum or like that. This is the first time you they raised.
I said that pointing out this discrepancy, a so-cause notice was issued. I have placed the reply to the so-cause, because the logist knows that if a right is available with a person to agitate or to raise his grievance, he should do it at the first opportunity. He cannot be permitted to improve his case at a later stage.
At this writ court, before the writ court.
Not only before the writ court, also even before the latter stage also. Like I said, the writ petition is the third stage. First was the so-cause before the authority. Second was before the appellate authority. And now the third one is before this honorable court. So the first opportunity was given to respond before the authority concerned.
Reply to the so-called.
Right, which was not done. Even it was specifically pointed out by the writ petitioner that those variations are very minor. That was the
answer.
first opportunity was, my lord, kindly appreciate the other aspect also. I told I submitted that the first opportunity was the inspection itself, because during the inspection also the petitioner got an opportunity to raise any kind of objection, and she has also done so.
Or explanation to that effect.
Right. And she has also done so in respect of certain discrepancies. I have shown the inspection report. But so far as this particular discrepancy is concerned, the inspection report is completely silent in connection with any response from the. So, in my humble submission, that is an admission on the part of the writ petitioner during the inspection that the report is completely fine. At least the recording which are been reflected in the inspection report is absolutely fine. This presumption, because there is no objection and it is a admitted position. Now, so the other issue which I was pointing out with regard to the disputed question of fact, there are two issues so far as the disputed question of fact which are very much relevant for adjudication of this writ petition. The first point which the writ petitioner has agitated is the recording of the weighing machine so far as 3 digit after the decimal is concerned. In my humble submission, if the inspection record shows, we do not know actually the weighing machines, whether the inspection report may only record only 1 digit after decimal, but actually the weighing machine could have shown another 2 digit. We do not know. If 2 digits were shown and all those 2 digits recorded 00, then there will be no variation at all. There will be no difference in respect of the variation recorded. So whether those were 00 or anything else, that is that cannot be decided without leading evidence.
Yes.
The other point which another important issue which the writ petitioner has taken is whether the inspection happened en route or at the godown. According to the writ petitioner, it happened at the godown. I have shown my record, and it is my categorical statement made in my affidavit that the inspection happened en route. So this particular fact will can change the entire scenario of the case. So it is very much material fact. The inspection, whether the inspection happened at the godown or the inspection happened en route, this is a very much material fact for proper adjudication of the writ petition, and this is highly disputed. So in my humble submission, in this particular proceedings, this particular aspect cannot be adjudicated. Now, this is in response. I will place 2-3 judgments on this particular disputed questions of penal losses. I will aware, but I will also place 2-3.
Yes, you place that.
Disputed question.
Yes.
Para 24, my lord.
Paragraph?
Paragraph 24. 2020. 10 HCC. It's nice. Before that, may I place the para 23 also? The High Court has based its order on the ground that after 5 monsoons, the final measurements could not be ascertained. If the measurements could not be done at the spot, the contemporary evidence and the measurement books prepared from time to time could be the basis for determining the liability of the appellants. The joint survey report is not an admitted measurement, though some officers might have signed it. The report prepared after completion of the work, wherein no such work done, is reflected in the measurement book. Prepared during execution of work is an attempt to inflate the claim raised by the writ petitioner. The entire amount claimed by the writ petitioner is disputed. It has been asserted that the entire payment due as against the claim of the work order had been made as reflected from the following table. So the issue was there were certain records produced where they were disputed, the parties to the proceeding disputed so far as the recording on those
Measurement.
and payments made, measurement and payments made are concerned. So the disputes were in respect of such recordings in the
Measurement
book, which were placed before the court. Now, based in such cases, the writ petition was also filed and the claim and money claim was raised. Now, para 24, in such a scenario, what the Honorable Supreme Court has said, therefore, the dispute could not be raised by way of a writ petition on the disputed questions of fact.
Yes.
Though the jurisdiction of the High Court is wide, but in respect of pure contractual matters in the field of private law, having no statutory flavor, are better adjudicated upon by the forum agreed to by the parties. Because here also, the losses may appreciate there is an arbitration clause in the agreement also. That so the parties have agreed to a forum, which is an arbitration procedure. The dispute as to whether the amount is payable or not, or how much on part of the appellant to infer that amount stands crystallized. Therefore, in absence of any acceptance of joint survey report by the competent authority, no right would accrue to the writ petitioner only because measurements cannot be undertaken after passage of time. Maybe the resurvey cannot take place, but the measurement books of the work executed from time to time would form a reasonable basis for assessing the amount due and payable to the writ petitioner. But such process could be undertaken only by agreed forum, that is the arbitration, and not by the writ court, as it does not have the expertise in respect of measurements or construction of roads.
This is
another one, Mala, on the same issue, 2021, 20 SCP, 450. Para 25, may I place first?
Para 25.
Yes. It is well settled that the High Court exercising its extraordinary writ jurisdiction under Article 226 of the Constitution of India, does not adjudicate hotly disputed question of facts. It is not for the High Court to make a comparative assessment of conflicting technical reports and decide which one is acceptable. Because in that case also, it was a report which was to be considered. Whether the report, because your office may kindly sees the other two paragraphs where from the exact the dispute will be cleared. Para 27, the High Court grossly erred in law as well as facts in passing the impugned judgment and order, overlooking the fact that the report of the Shedgiri and Associates was not a certificate of stability as stated in the report itself in note number 1 extracted above. It is not understood how the High Court could have been satisfied that the stability of the building could be restored by repair in the manner directed. The High Court patently erred in passing the impugned order. The impugned order cannot be sustained. So it was also in based on certain report being placed before the court. And then the parties have disputed, have conflicting suggestions on the report. Arbitration. So on disputed question, these two judgments, my lord, will.
Yes.
Even your lordship have also passed certain other orders in other similar kind of relating to contractual dispute in relation to this LPG distributorship, retail outlet dealerships,
yes,
of the oil companies, and those disputes are all related to the contracts. And in such cases, your lordship has held that since there is already a agreed forum of arbitration for adjudication of such kind of disputes, the parties should refer to that forum. The writ petition is not maintained, and I can also, because I appeared in one of those cases for Indian Oil Corporation. And I will give that the reference of the order which your losses have passed in our. And the other point which was taken in the writ petition was with regard to tampering of the seal of the cylinders. According to the writ petitioner, if the cylinder is underweight, that means the cylinder has been tampered, and since the cylinder has been supplied by the oil corporation, that even if there is a case of tampering of the cylinder, then it is the responsibility of the Indian Oil Corporation, because it has been supplied by Indian Oil Corporation.
If there is no such tampering and the weight appears to be less, then it is the responsibility of the Indian Oil Corporation and the plant who serve the
Yes.
This is the argument.
Yes. The argument was in this case, there is no case of tampering.
Yes, in this case, there is no case of tampering. So the petitioner cannot be made liable.
Right. In respect of that, my submission is, my lord, it is a fact that there is no case of tampering. So far as the SOCOS proceedings is concerned, the case is, there is no case made out for tampering.
Yes.
The our categorical stand was that this cylinder is the underweight cylinder must have been supplied by the corporation also itself. It has been supplied from the bottling plant. The underweight cylinder has been supplied from the bottling plant.
Yes.
And so it was the responsibility of the distributor to return it back and not keep it for supply to the customers. That is the allegation.
Yes.
The charge is to supply a underweight cylinder to a customer. Because the guideline says that if there is an underweight cylinder being supplied to the distributor concerned, then it is the responsibility of the distributor to keep that cylinder aside and send it back to the bottling plant. However, in this case, what was done, it was kept at a place for supply to be made to the customer, and it was accordingly weighed and made for delivery to a customer en route. So
The en route van.
Yes. So it was the en route van. It was not found at the godown. It was not at the godown premises. It was on the van. No one, a van cannot be uploaded with a defective cylinder. That is my stand. Because the guideline says no defective underweight cylinder can be uploaded on a van, can be loaded on a van for delivery. Even if assuming without admitting that the van was within the godown. The petitioner's case was that the van was within the godown and the inspection happened at the godown. This is the case made out in the writ petition by the writ petitioner in the writ petition, that the van was at the godown premises and it was not en route. Assuming that to be true, even in that case also my humble submission is
Why
that
it is placed in the en route van?
yes, even then also there is a violation. Because the guideline says underweight cylinder can't be loaded on a van.
Show me the guideline.
Right. First of all, may I show again, Manoj, clause 1.2 at page 48. Page 1, clause 1.2 at page 48 of the guideline of the writ petition.
Yes.
The distribute unloading. This is a process to be complied before loading. While unloading from
the truck. From the storage godown.
And who has to do this job? The distributor to carry out the following. It is the responsibility of the distributor, not the oil company. Separate area should be marked in the LPG storage godown for keeping filled, empty and defective cylinders for each type of cylinders. The platform type digital weighing scale of at least count plus minus 10 grams should be checked with standard weight for accuracy. While unloading filled cylinders, weight of 10% cylinders taken randomly should be checked and records should be maintained in the prescribed format given by OMCs. Cylinders that have net weight beyond permissible limit should be returned in the same truck. Record the same should be maintained. Pausing here for a moment, my lord, the clause 4 says, because the check has to be done on a random basis.
10%.
10% of the total cylinder been delivered. So in that random check, if a cylinder is found to be underweight, then instantly it has to be returned back on the same truck. Now suppose what happens if there are other underweight cylinders which were not randomly checked, then the provision of clause 1.4c will apply. The next page. All the cylinders taken out for delivery should be checked for correctness.
Yes. Clause 1.4c.
Yes. All the cylinders taken out, and also, my lord, this is also part of clause 1. Kindly see at page 48 top. Clause 1. Procedure for handling of LPG cylinder by distributors. So all the clauses under 1, all sub clauses of clause 1 are for the distributor to comply.
Yes.
All the cylinders taken out for delivery should be checked for correctness of net weight on the platform type digital weighing scale. So before loading, taken out for delivery means before loading it on this delivery van, the first step for taking out of delivery is loading a particular cylinder on the delivery van. So before the distributor loads the cylinder on the delivery van, then before that that particular cylinder has to be checked. The weighment of that particular cylinder has to be checked by the distributor on the platform type digital weighing machine at the godown.
Yes.
And if it is found the cylinders that have net weight beyond permissible limit of such and such as amended from time to time should be segregated and returned to the concerned bottling plant. So even at this stage also it can be kept, it can be segregated and returned to the bottling plant. So this provision for segregation has to be done at the godown before it is taken out for delivery. Kindly see in the next clause, clause D. Cylinder with correct net only should be taken out for delivery to the customer.
Yes.
Delivery staff engaged for effecting home delivery should be in uniform and have the identity card issued by the distributor while delivering. Now kindly also see clause N. The next page, the last clause N. At the time of inspection. So this is at the time of inspection. Stock of equipment recorded in the inspection report and signed by both parties shall be firm and final. Well, I have submitted before your lordship that the inspection report was prepared. Inspection report records the remarks of the inspection team as well as the remarks of the distributor concerned in respect of such remark of the inspection team. So that's why this clause is there, because both the parties have the right to record their observations on the inspection book. That's why that becomes final and binding. The distributor later on showing some documents and making good the inventory will not be considered. The another issue which was taken in the issue which is taken in the writ petition is that showing the appellate authority's order. Placing the appellate authority's order, it was further pointed out that there was a subsequent inspection.
Where is the order?
The order starts from page 133.
Yes.
Because the initial inspection, which is the inspection in dispute, the so cause proceedings initiated based on an inspection carried out on 14 July 2023. If you also sees the so cause notice at page 83.
Yes.
This has reference to the inspection done by QRC officials on 14 July 2023.
14 July is the first inspection.
In my humble submission, this is the
only
because there are regular inspections been made.
Carried
But so
out.
far as the inspection, which is the subject matter of dispute, based on the inspection, so cause notice was issued. Thereafter, an order was passed, and an appellate authority has also passed an order. That particular inspection happened on 14 July 2023. If you also once sees the appeal, the relevant portion is at page 116. The appeal starts from page 115. The appeal preferred by the writ petitioner before the appellate authority.
Yes.
At page 116, third paragraph, it starts with regrettably. Page 116.
Yes.
Regrettably, third paragraph. The speaking order dated such and such was issued without due consideration of the facts highlighted in the inspection report. So he is also relying on the inspection report, no other document. I am also relying on the inspection report, which were presented in response to the concerns raised during the first inspection. Here he is relying upon a second inspection also. Despite providing detailed calculation, it appears that there is a misunderstanding between our physical and system stock as perceived by company officials. We request a thorough review of both inspections report, particularly the pending report from 18 July 2023 to ensure that all relevant facts are taken into account before any further action is taken. Just before that paragraph, my lord, as per our records, just a paragraph before that, as per our records, 2 inspections were conducted by the QRC team on 14 July 2023 and 18 July 2023 simultaneously. We were under the impression that the second QRC inspection carried out by the QRC team aimed to re-verify the facts. So it is a case of the petitioner that if there must have been some irregularity or some disputes or some doubts in respect of the first inspection. That's why another inspection was carried out on 18th of July to clear the doubts, to re-verify the facts observed in the first inspection, particularly after we contested the initial findings regarding the weighment of the cylinders and reconciliation of the stock. While we received the report of the first inspection carried out on 14 July 2023, we are still waiting the second report from the inspection conducted by an additional QRC team led by Mr. Such and Such on 18 July. So to improve the case which was made in the reply to the show cause in respect of the charges level against the petitioner with regard to the inspection carried out on 14, a point was taken that there must be some misunderstanding, some misconception with regarding the recordings made in the report.
Yes.
That's why on the request of the petitioner, another inspection was carried out on 18. But even in here also, the petitioner categorically refers and relies on the inspection report, first inspection report. And this was considered by the appellate authority, and it was found that no inspection was carried out on 18th of July 2023 to re-verify the facts of the inspection carried out on 14th of July. And the losses will also see that both the orders, the order of the authority in response of the show cause,
yes,
is a well-reasoned order. This starts from page 106. The orders categorically specify the each and every charge which was made out. First, the charge from the show cause, then thereafter the distributors reply to against that particular charge. Thereafter, the remarks of the inspection team, and thereafter the decision of the authority. For each and every charge, a detailed, well-reasoned order. No case of violation of principal justice has been made out. the process was duly complied with. There has been no anomaly, there has been no malafide so far as the process been conducted.
Yes. No violation of natural justice.
My lord. It's a well settled principle, my lord. In case there is no in contractual disputes, in case even if the respondent is a state within the meaning of Article 12, even in that case also, in respect of contractual disputes, if a case of violation of principle of natural justice is not made out, if a case for violation of Article 14 is not made out, then the writ court should not interfere. Because the writ court is not sitting in appeal. These are all factual things which had happened, and all these factual things were duly considered by the authorities.
Yes.
There cannot be any, in a writ proceedings, cannot be any reappraisal of evidence.
Very.
Now, if this similarly, even if you see the appellate's authorities order at page 133, it also is a detailed, well-reasoned order considering each and every aspect of the matter, like the allegations, the charges framed against the petitioner in the so-called proceedings. Thereafter, the reply of the petitioner against the charges. Then the order passed by the authority concerned, and thereafter the decision of the appellate authority. A well-reasoned, detailed order. And even the appellate authorities has also, like, there were not, this was not the only irregularity which was found. There are certain other irregularities were also found, and certain other penalties were also imposed. So in respect of some other penalties, the appellate authority has considered and accepted the case made out by the writ petitioner, and accordingly the penalty was reduced.
What is the ultimate penalty?
My lord?
What is the penalty imposed?
The penalty imposed, my lord, it's at page 146, 1,90,564. The appellate. Even if you also see page 113 and 113 and 14, here also the authority concerned in respect of the so-called proceedings has also reduced certain penalties, because all the charges which were leveled against the the petitioner in respect of, like, there was certain discrepancy in the stock, and there was an allegation made that the delivery boy was not in uniform, which is also a violation. So ultimately, those irregularities were found to be incorrect, and the submission made by the writ petitioner was accepted, and the quantum of the penalty was reduced.
Yes. $1,90,566. This is one major irregularity as first instance.
Yes.
Okay, that's all.
And I may also place the only indicate that arbitration clause in the agreement. The agreement has been annexed, my lord, at page 26 of the repetition.
Thirty-nine is the arbitration clause. 37. 39 is the page.
37A is the arbitration.
Yes.
At page 39.
At page 39.
Just kindly sees the prayers also once, my lord. What are all have been challenged in the repetition? The challenge is the two orders. Page 22. Writ of nature mandamus to issue setting aside the inquiry report. Now kindly see setting aside the inquiry. Now here the first time, at the third appellate stage, the inquiry report has been challenged. However, in
14th of September 2023 is the inquiry report. 14th of September.
No. 14th
MGT
of
order.
Yes. The order after conclusion of the SOCOS proceedings, that first
The
authority
first order.
the first order, that is of 14th of. But before that, he has also setting as the inquiry report. Now this inquiry report means the report of I do not know, like in the body of the petition there is not a single statement in respect of the inquiry report. Which document has been referred to as an inquiry report, I do not know, my lord. Perhaps the inspection report has been referred to as the inquiry report, but none of the there is no case made out in the writ petition challenging any anomaly or any discrepancy in the inquiry in the inspection report. And also I have shown your losses the clause 1.4.n of the guideline, which says the inspection report has to be signed by both the parties, and after the parties sign the inspection report, that the recording made in the inspection report becomes firm and final, because both the parties get their respective chances to make their respective observations. The other thing which was challenged is the first authorities report and the appellate authorities authorities order and the appellate authorities order.
Yes.
Now why granting the request having passed without application of mine discriminatory perverse in violation of Article 14 and 21. In my humble submission, this particular prayer is not maintainable, because a detailed order by both the authorities following the due principles of natural justice. Even the next prayer is also in respect of these two orders. All the prayers are in respect of these two orders. So far as the action is concerned, during the inspection, or during the so-called proceedings or the action of the inspecting team during the during the inspection is not subject matter of challenge, no relief. So far as the proceedings conducted by the authorities concerned, no allegation. Okay. So in my humble submission, the relief sought for in the writ petitioners should be rejected. This is my humble submission. Thank you. Now, only on the next date when my learned friend will give reply, I will only just supply the number of the writ petition of the orders also. In those matters, in your losses have held that in this kind of matters, the appropriate remedy is arbitration.
Let them give me an advance intimation about those judgments.
Just one judgment.
Whatever.
Yes.
Whether it is one.
So today, is it possible?
My lord, not today. My lord, another prayer I will be making. My lord, if it is possible to fix the matter post 15th April, my lord. My clients are undergoing some medical procedures. They are not available now.
After 15th April?
15th April. Not any
Very long.
My lord, it's a humble request. I will. I can assure.
Only
I
the
can
law
assure.
will be now replied on.
Yes, I
On
can assure.
facts, reply cannot be on facts, my lord.
No, I understand.
I can assure that it will be done on a single hearing.
And even today also, my lord, I suppose there is a. Yes.
I think
24th order.
it is.
24th.
My lord, I'm grateful.
24th of April, man.
Argument on behalf of the Indian Oil Corporation Limited concludes. Let the matter fixed on 24th of April 2025 for argument on reply on behalf of the petitioner. At 2 p.m.
আমাকে একটু হোয়াটসঅ্যাপ কিংবা ইমেল করে দিবি
Marked at 2 p.m. দেখুন marked at 2 p.m. 2 p.m.
My lord will.
Well, your losses has heard extensively. If your losses may kind enough to mark it part hard.
It's part hard.
Pattern matter.
Part hard বলেই তো চলছে grateful.
Call the matter. Next matter. Report দিয়েছে কি দিয়েছে বললে রিপোর্ট okay registered audience could not furnish report because the banking certain name of the bank and particulars are not forwarded to him, and also due to the ending season like that
31st
March is going on.
That was in respect of prayer C.
Prayer C.
But as regards my other prayers A and B are concerned, basically A, practically there may not be any hearing in respect of A, because earlier also I have filed an application which was allowed by the Honorable Court with the direction on the respondents to deposit 10 crores. And this is for the subsequent accrual of the interest, my lord.
Okay. No, I seek a report from the register only in respect of prayer C.
Yes, my lord. So I am seeking an order for prayer A, my lord.
Give me the application
My lord, may I be permitted to file my opposition
in respect of prayer A.
in respect of the application?
Application.
I think.
Master summons the master summons.
But so far as the execution application is concerned, your lordship had been initially pleased to pass an order sometime in July when your lordship was hearing my section 34 application, and your lordship had been pleased to hold that it is maintainable and not barred by limitation as Mr. Surana had contended, your lordship had been very pleased to record right at the end that your lordship will take up hearing of the execution application after the completion of the hearing of the section 34. So today, my lord, to make this submission that this execution application should be heard, further orders should be passed, perhaps, my lord, that situation does not arise because your lordship is hearing all the 34s, and it was your lordship's pleasure and had fallen from your lordship that the execution will be heard after the disposal of these section 34 applications. My application, Mr. Surana's application, and the third application, whatever that might happen to it. Because in these execution applications, I have also taken a preliminary point of the jurisdiction of this court so far as whether this is executable before this court on the point of territorial jurisdiction. So my humble prayer is, my lord, kindly hear of the section 34 applications. They could have been heard of long time ago, but Mr. Surana has taken his time. Be that as it may, my lord, I am not raising any issue out there. But once the section 34s are decided, one way or the other, either I will succeed or Mr. Surana will succeed. If Mr. Surana succeeds, then the execution application has to be heard. In the event I succeed, my lord, then the execution application becomes infructuous. Whatever monies that Mr. Surana has received pursuant to orders passed in the execution proceeding will have to be returned to me. But that issue will have to be decided once the 34s are, my lord, decided once and for all. And your lordship is hearing that on a very regular basis, if I may say so. Every Thursday and Friday is practically devoted for these matters.
But as far as
your prayer is leave be granted to the petitioner to execute the award for the balance sum of rupees such and such, which amount is not secured by the judgment letter. B is order be passed in terms of column 10 of the tabular statement of execution application. Okay, order passed directive and correct the balance. Yes, Mr. Surana.
I agree with Mr. Medora that your lordship has stated that this petition, this petition, execution petition should be heard only after completion of the section 34. Yes. I'm not on that. I'm only seeking an order from your lordship for securing the interest amount. Now, it is a settled principle of law that filing of section 34 will not create a bar on execution.
No, I understand, but you want that award for balance sum of rupees 43 crore.
I'm only securing, my lord. My humble summary is for securing, nothing else. I am not getting that money. I'm not seeking an order that payment should be made to me. I'm only seeking that this payment should be secured, and there is no bar. Let me place an order by the judgment of Supreme Court, my lord.
No, however, the matter has to be heard. Otherwise,
basically no hearing is because earlier when I filed an application for around some 14-15 crores, it was heard by this honorable court when it was heard by Justice Mosmi Bhattacharya, and her lordship has passed an order for payment of 10 crores. They moved an SLP before Supreme Court. They obtained an injunction. That injunction continued. Still, it is continuing. This prayer is only for subsequent accrual of interest, my lord. Nothing else, my lord. I'll just place this order before your lordship, my lord. Just 3 paragraphs, my lord. Paragraph 27, 28, and 29, my lord. Can I place it, my lord?
Yes.
Under section 36, where the time for making an application to set aside arbitral award has expired, the award might be enforced in accordance with the provisions of CPC in the same manner as it were a decree of the court. Section 36(2) makes it clear that filing an application for setting aside of an award under section 34 is not to render the award unenforceable unless the court expressly grants an order of stay on the operation of the arbitral award in accordance with the provisions of section 3 of section 33, section 36 on a separate application made for that purpose. My lord, there is no stay on the award act. Absolutely no stay. And if there is no stay, I am entitled for execution, my lord. Section 34 application will not create any bar. Then, my lord, 28. Once an application under section 2 of section 36 is filed for a stay of operation of the arbitral award, the court might, subject to such conditions as it may deem fit, grant a stay of the operation of the award. For reasons to be recorded in writing, the court is empowered to impose such conditions as it might deem fit and may grant a stay of operation of the award, subject to furnishing of security covering entire amount of award, including interest. Now, they filed an application under section 36, my lord. That was rejected by an order of 28th of April 2022. They made a review petition. That was also rejected by an order passed on 1st of September 22. They moved an application, SLP, before Supreme Court, my lord.
Mr. Student, I have understand. Issue is that I am sessing over section 34, two applications.
My lord.
Two applications are there.
My lord.
So that orders
My lord.
under section 34 directly affect your amount. Directly affect your amount.
I fully, so that is what I am saying.
Maybe enhanced, maybe reduced, anything.
My lord, my humble,
I know there is no order of stay like that.
my humble submission is para 27. There is no bar. Section 34
I
would
know
not
there
create
is
any
no bar, but I am sessing over this matter. I am not left the matter.
I'm seeking only a securing. I'm not seeking a payment to me. I just seek a securing of
I
that amount.
understand you want the securing.
That's all. It was earlier passed, my lord. They did not succeed earlier also.
But as I have observed that the matters, the execution has to be heard after the completion of the 34.
I'm not making a
justified.
I'm not making a request to hear the application. I'm not making a request to hear that application.
Let the application be pending. After completion of 34, I will hear.
Let my humble submission, I am not seeking to hear
If
the
I
entire
pass any
matter.
order, if I pass any order to the judgment debtor to secure any amount,
My lord.
whether maybe ₹1 or maybe 1 crore,
My lord.
that is maybe whatever may be. But that the deposition of that amount, if goes otherwise in favor of the decree holder,
they will get it
again.
I'm not seeking it should be.
And if it goes in favor of you, again further amount would be directed to be deposited.
My humble submission is I am not seeking that payment to be made to me.
I understand.
I'm only seeking
it has
that
to
let
be
the payment be
secured.
deposited with the lordship.
Okay.
Nothing
Very
else, my lord.
So,
and since there is an order of the Supreme Court that section 34 will not create a bar.
No, that is not that is not the law. It shall not create any bar without stay.
My lord, under the Calcutta High Court judgment is also there that it has to be made. I'll just place this order, my lord. Enter the agent. Just paragraph 10 and 11, my lord.
Yes.
Paragraph 10 and 11. I have considered the arguments placed by both sides and see no reason in the present case to reduce the security to be provided by the award debtor. Accordingly, the award debtor is directed to deposit a sum of rupees 31.7 crores, principal minus 4.84, which they have already paid earlier, with Punjab and Sindh Bank so and so, by way of cash deposit before the registrar original sign. The balance amount with regard to the interest at the rate of 12% per annum from 14th of March to so and so should be deposited by way of a bank guarantee from a nationalized bank before the registrar original sign. The above deposits of the cash security and bank guarantee should be made by the award debtor within 4 weeks from the date. In the event the said security is provided, the execution application being so and so shall also remain in state. In default, the award debtor shall be at liberty to proceed with the execution application in accordance with law. So my humble submission, my lord, is that since there is no stay on the award, I am seeking a security for the amount of interest. Let it be made either by cash or by bank guarantee with the registered, my lord. Nothing else. Earlier also I have filed an application and I have succeeded then and they have lost that. They did not get even a suitable order even from Supreme Court also, my lord. That injunction is continuing, no doubt about that.
Okay. What a report is.
And yet there is another judgment also, my lord. The Calcutta High Court itself has said The law is well settled. I'll just place it before your lordship.
No, Mr. Madura, you just not taken my point. I am not going to pass any order in this matter. If you want, I can pass the order.
Well, that's
Otherwise, it would be difficult for me to deal with the matter.
I just wanted to differentiate, my lord. I am not seeking to hear execution petition. I am only seeking a direction on the respondent to make a security for the interest amount only, nothing else, my lord.
If that order be passed, so that I can proceed with the execution case. Any order if I pass, even if I have passed the order in respect of your prayer in C, that is also proceeding to the execution case. That I personally said that 34, all the 34 I am taking note of. So let it be there with the execution case.
Absolutely, your lordship's choice. My lord.
Yes.
I just wanted to make my submission. That since there is no bar.
No, Mr. Madura, I am hearing you. No issue. Let me complete the matter in my way. Thereafter, your first matter also stalled for the completion of this matter, so that there be a conformity of the judgment.
At least, my lord, if I am not
Otherwise,
wrong,
it is ready with my chamber.
if I am not incorrect, your lordship must have come to a conclusion. Where do I stand and where Mr. Midori
Yeah.
stands?
That after completion of both the applications, I will pass the order. Thereafter, execution.
And I have already been granted 9.22 crores even without a security also. That shows the strength of mine in the matter, my lord. 9.22 crores have been given even without securing, even without demand of any security from me.
Very.
That was so because there was no stay. That is the reason.
Yes.
Not because his case is good.
No, that is not the case.
Okay. Please take down.
गलत मत बोलो मेरे ब्राजी
कितना घुमाएंगे आप
गलत मत बोलो
क्या झूठ मत बोलिए
झूठ मैं नहीं बोलता हूँ ये मान के चलो
Affidavit in opposition for and on behalf of the respondent number 3 against the applications being GS6 of 2025 filed by the decree holder be taken on record. Full stop. Learned register original side submitted a report containing inter alia seeking the particulars of bank where from the report has to be collected. The office is directed to supply the necessary particulars to the learned register original side within a week. Full stop. Let the matter appear in the list.
I hope, my lord, from 1st of April there are certain changes.
1st of April there may be certain changes, but I have the determination. This is the assigned matter.
No,
I have to do this matter.
No, what I wanted to submit, my lord, from 1st of April, your lordship has been loaded even with the original side matters also. So it can be heard even other than Thursday and Fridays also, I feel.
Let the matter appear. I have the determination of group 8 already running and group 1.
Earlier, your lordship were hearing only appellate matters, if I am not incorrect.
No.
Both.
All. Moreover, it is an assigned matter. You don't have any difficulty regarding
this will follow your lordship. This will follow your lordship wherever your lordship goes.
No problem.
Okay.
This is like the Vodafone advertisement. Network follows.
But a date has been fixed for 4th of April in the other matter. So can it be on the same day, my lord, 4th of April?
4th of April. Okay. 4th of April. The report
it
would
can
be
be on 3rd of April also, my lord.
now come on 10th. 10th of April, the 1 week to be time to be given to the register to submit the report. 1 week. So regularly it will appear on 10th. 10th of April at 2 p.m.
No, my lord, but then unless the 34 is heard, your lordship will not hear, then there is no point in fixing a date also. This is what I am thinking.
No, I cannot hear you.
Your lordship will not hear this application unless 34 is over.
Yes. So 34 has to be concluded first.
34 dates have already been fixed, I believe.
Yes. 34
Mr. Surana is saying, what is the point of listing this matter? I think if the 34s are not decided first.
No, if I find that there are some less strength in group 1, then I will fix those matters in the first half or second half like that. Okay. Let me take up the determinations first. Thereafter I will consider.
So my So it is fixed on 10th of April.
10th April.
Grateful,
10th of
my lord.
April. Okay. I'm grateful. ma'am. One second.